Good morning, ladies and gentlemen. We're going to now commence the formal part of our agenda with docket item number 1. Docket number 2024-041, cause number 472-03. In the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interests, including the compulsory pooling of certain non-consenting owners in the Devereaux, Utah, 1-14, 4-1-13-24-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations in sections 13 and 24, 4 South, 1 West, USM, Uinta County. Mr. McDonald, welcome.
Thank you, Madam Chair. Fred McDonald of Counsel with Lear & Lear on behalf of the petitioner, OVINTIV USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
John Rogers with the division.
Thank you. This was heard by hearing examiner. I guess we'll proceed with Mr. Rogers.
Okay, thank you. Good morning, Chairman Garrison and members of the board. My name is John Rogers, as I just indicated, and I'm an environmental manager at the Division of Oil, Gas, and Mining. I act as a hearing examiner in this proceeding as directed by this board. Mr. Gary White was the Attorney with the Attorney General's office was my counsel. A hearing examiner proceeding was conducted in this manner on Wednesday, August 21st. And Chairman Garrison just read the request for agency action. Are you fine if I don't repeat that? Okay, great. This proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public or any party were present at the hearing. Mr. Andrew Haynes represented the division for the Attorney General's office. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Peter Burns, a senior land advisor, and Mr. Christopher Wall, a senior reservoir engineer, both from OVINTIV, and reviewed by me prior to the hearing. Mr. Fred McDonald was present at the hearing and acted as counsel for OVINTIV. Both of OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. On August 12th, 2024, the division filed a response to OVINTIV's request for agency action expressing a non-opposition to granting of the request. At the conclusion of the hearing, Mr. Andrew Haynes, on the behalf of the division, stated support for the request for agency action. No other party filed a response to the request for agency action or appeared or participated in the hearing. As a consequence of their failure to timely reply or give a response and appear at the hearing after proper notice, Mr. McDonald made an oral motion at the beginning of the hearing to declare the compulsory pooled parties identified in this order in default per Utah Administrative Code, which I granted. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses presented on behalf of OVINTIV, and after reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommended the following. OVINTIV has provided sufficient and adequate notice of an opportunity to put the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommended that 300% non-consent penalty be opposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to the compulsory pooled non-consenting parties. For your interest, OVINTIV USA, Inc. Is at 93.02% working interest owner. Non-operating working interest owner under JOA is 6.76%, and the compulsory pooled parties is at 0.21%. There's some history in this area for as far as pooling and spacing. It's spelled out very much detailed in the order. Would you like to have you give you a high-level summary of that?
Yes, if you could summarize it, please.
Okay. The historical spacing and pooling of this area, let's envision section 13 on top of 24, a stand up. Okay, in section 13 there were 8 wells, and it was established as a 40-acre pooling in December 2nd of 2010. And it was compulsory pooled on January 13th, 2011 into Order 266-03. In the lower section, 24, 11 wells were in production, and it was not spaced, and they were produced under the rule of capture. There was no compulsory pooling in that section. On February 23rd, 2018, drilling at DSU established for 13 and 24 in Order 600-02 was established. And at that time, with that pooling, it waived any further re-recruitment from that pooling from the previous matter back in 2010. And then there was conversion following the first production of the Devereaux well, which we're talking about today. It was spud on April 2021, and its first production was September of 2021. So that's the history of pooling and spacing in that area. OVINTIV's counsel, Mr. Fred McDonald, prepared the findings of fact, conclusions of law, and order granting its request for agency action. Both the division and I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for your review and execution. I will take questions at this time if you have any.
Thank you. Division, do you have any questions for the
No additional comment from the division.
board? Do you have any questions? Okay. Proceed.
Okay. At this time, I submitted that for your signature. And
Mr. McDonald, do you have any closing?
Just a
thoughts?
couple points, Madam Chair. Mr. Burns and Mr. Wall are available virtually if the board does have any questions for them. Otherwise, Mr. Rogers has done an excellent job summarizing the hearing. We appreciate his time and effort with that, and we would ask that the board enter it, the order. And again, the order, because we didn't know who was going to be here and what the vote was going to be, there are some blanks that need to be filled in. I just want to point that out to you.
Thank you.
Thank you.
Division, any closing comments?
No, just in agreement with Mr. McDonald and Mr. Rogers, and we reviewed the order, and division approves of it as well.
Board, do you have any comments, questions?
And approved of it.
Before we vote, I should announce we have a quorum here. We are absent Al Walker and Steve Church, but the remaining 5 members are here. Do I have a motion? Would we like to proceed?
I move that we approve the request for agency action.
Second?
Second.
All in favor? Opposed? Please note it was unanimous. Thank you, Mr. McDonald. Are you here for, you're here for the second one also. We're moving on to docket item number 2. Docket number 2024-042, cause number 132-47, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Lamb, Utah 1-16, 4-1-9-4-1H well, in the drilling unit established for the production of oil gas and associated hydrocarbons from the lower Green River Wasatch Formation, comprised of sections 4 and 9, 4 South, 1 West, USM, Duchesne County, Utah. Appearance of counsel.
Fred McDonald of Counsel with Lear & Lear on behalf of Petitioner OVINTIV USA, Inc.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And hearing examiner.
Assistant Attorney General Gary White on behalf of John Rogers, the hearing examiner.
Thank you. Mr. Rogers.
okay. Thank you, Chairman Garrison. Good morning to the members of the board and Chairman Garrison. My name is John Rogers, as I indicated, and I'm an environmental manager with the Division of Oil, Gas, and Mining, and I acted as a hearing examiner for this proceedings as directed by this board. Mr. Gary White was of the Attorney General's office was my counsel. A hearing examiner proceeding was conducted in this matter on Wednesday, August 21st, and Chairman Garrison has summarized that, so I won't repeat that. The proceeding was held as an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public or other party were present at the hearing. Mr. Andrew Haynes represented the division from the Attorney General's office, and during the proceeding, 2 sworn declarations and exhibits were admitted in evidence from Mr. Peter Burns, a senior land advisor, and Mr. Christopher Wall, a senior reservoir engineer, both of OVINTIV, and reviewed by me prior to the hearing. Mr. Fred McDonald was present at the hearing and acted as counsel for OVINTIV. Both of OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. On August 12, 2024, the division filed a response to OVINTIV's request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Andrew Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request for agency action or appeared or participated in the hearing. As a consequence of their failure to timely reply or give a response and appear at the hearing after the proper notice, Mr. McDonald made an oral motion at the beginning of the hearing to declare the compulsory pulled parties identified in the order in default per Utah Administrative Code, which I granted. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in the connection of the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull non-consenting parties. For your interest, the working interest owners, OVINTIV USA Inc. 98.06%, non-operating working interest under JOA 1.86%, and the compulsory pulled interest 0.07%. Again, I'll present some history of the area, and this is a very simple one. DSU was entered as order number 139-150 on February 2018, and the Lamb well was first produced in May 27th of 2021. OVINTIV's counsel, Mr. Fred McDonald, prepared the proposed finding of fact, conclusions of law, and order granting its request for agency action. Both the division and I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. I'll take any questions at this time if you have some.
Board, do you have any questions? Mr. McDonald, do you have any closing?
No, Madam Chair. Again, Mr. Burns and Mr. Wall are here in case the board had any questions to answer them virtually. Otherwise, again, Mr. Rogers done an excellent job summarizing. Again, we appreciate his time and acting as hearing examiner on this. And again, the order that's in front of you has some blanks that need to be filled in based on who's here and what the vote is. Thank you.
Division, do you have any final comments?
No, just we're in agreement with Mr. Rogers' report, and we have reviewed the order, and we approve of it.
Board, any further discussion? Do I have a motion?
I move that we approve the request for agency action consistent with the recommendations of the hearing examiner.
I second.
All in favor, please say aye.
Aye.
Any opposed? Please show that it was unanimous. Thank you.
Thank you, members.
Thank you. Do we have the order? Okay. We're moving on to item number 3. Looks like Mr. Mayo may need some setup time.
I think I'm ready to go because hopefully there's no presentation for this one.
Okay.
Thank you, though.
All right. Docket item number 3. Docket number 2024-045, cause number 132-48. in the matter of the request for agency action of OVINTIV USA, Inc. for an order partially vacating the order entered in cause number 139-114, and instead pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the 9 Bruce wells identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Formation, comprised of all section 14 and 23, 3 South, 2 West, USM, Duchesne County, Utah. May we have appearance of counsel? Mr. Mayo,
Mitch Mayo of Lear & Lear PLLC on behalf of OVINTIV USA Inc.
Division,
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
and hearing examiner.
Assistant Attorney General Gary White on behalf of hearing examiner John Rogers.
Thank you. Mr. Rogers, please proceed.
Thank you. Good morning, Chairman Garrison and members of the board. My name is John Rogers, and I'm an environmental manager with the Division of Oil, Gas, and Mining, and I acted as hearing examiner in this proceeding as directed by this board. Mr. Gary White was my attorney from the Attorney General's office. A hearing examiner proceeding was conducted in this matter on Wednesday, August 21st, as indicated by Chairman Garrison's review of that matter. The proceeding was held at the anchor position in Department of Natural Resources building in Salt Lake City, Utah. No member of the public or any party were present at the hearing. Mr. Andrew Haynes represented the division from the Attorney General's office. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Ashley Ellison, Senior Land Negotiator, and Mr. Christopher Wall, Senior Reservoir Engineer Advisor, both from OVINTIV, and reviewed by me prior to the hearing. Mr. Mitchell Mayo was present at the hearing and acted as counsel for OVINTIV. Both OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. On August 12, 2024, the division filed a notice of non-response to OVINTIV's request for agency action, expressing non-opposition to the granting of the request. As the conclusion of the hearing, Mr. Andrew Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request for agency action or appeared or participated in the hearing as a consequence of their failure to timely reply or give a response and appear at the hearing after the notice. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations were admitted as exhibits, and in hearing the live testimony presented at the hearing, I found and recommended the following. OVINTIV has provided sufficient and adequate notice for opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable and should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of these wells. I therefore recommend a 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Working interests in the area was OVINTIV USA Inc. 96.59. Non-operating working interest owners under JOA was 3.23, and compulsory pooled interest as 0.18%. The history in this area is more complex than others, and so I'd like to review it this time. Envision 2 sections, 14 sitting on top of 23. In October 1983, a 131-51 order was established for a 640-acre DSU in Section 14. May of 2012, order number 139-90 provided a 640 drilling of DSU in Section 23. Newfield, who at that time drilled these 2 wells in the areas, the Mullen well, a vertical in Section 14, and a Morrow well in a short lateral in Section 23. Those are now operated by OVINTIV. These 2 wells were later pooled into Order 139-114. And at this time in this matter, they were being asked to partially vacate that order. So Board Order 139-134 established on July 2015 a stand-up drilling unit for 14 and 23. First production of a long lateral conversion date was established by the drilling of the Bruce 1H well on March of 2019. And on that date, recoupment was waived for the Mullen and Morrow well that were pulled initially back in, what year is that? That was back in, where was that? 2012. Okay. OVINTIV chose not to seek compulsory pulling of the 1H well, the Bruce 1H well, and bring them in at 8/8 for the proportional share, and no risk compensation or acreage-weighted royalty was applied to them. So this time, we now have this drilling unit set up for pooling and vacated the old pooling and spacing orders. Any questions at this time?
Board, do you have questions? Back to you, Mr. Mayo, for any final comments.
None, just except to thank everyone for their time and attention. Also to note that Ashley Ellison and Chris Wall are available online if there are questions. And just to reiterate, this was a little more complicated, involved fact pattern than a lot of these compulsory poolings. But, you know, OVINTIV and myself in particular, we take seriously when we request hearing examiner matters, they are not for novel issues. They are for issues that have been resolved before. And so we just want to make sure the board's aware of that as we go through this process. We're constantly watching that, and if there's something that hasn't been addressed before, we will bring it directly before the board. But in this case, it was just kind of a screwy fact pattern that we've seen before. So that's my only comment. Thank you.
Thank you for the clarification.
Madam
Division.
Chair, Madam Chair, point of order. Mitch, you have one exhibit that has not been admitted, corrected Exhibit 8. Do you want to admit that?
Thank you. Yes, we the exhibit that identifies the working interest percentages. There are always often changes during the pendency of the request where someone will reach out and lease. That exhibit was updated, and the corrected exhibit was submitted after the fact. However, as board secretary pointed out, at the hearing examiner hearing, we asked for admission of Exhibit 8, not corrected Exhibit 8. So I'd just like to clarify for the record that it was corrected Exhibit 8 that was admitted, and to the extent necessary, ask this board to admit corrected Exhibit 8 to the record.
So admitted.
Thank you.
Thank you. Division.
Thank you. No additional comments. The division's in agreement with Mr. Rogers' report. We reviewed the order that was proposed, and as Mr. Mayo points out, there's a little bit different fact pattern here, but it was still fell within the guidelines of what we're used to seeing. And so with that, we were in support of the RAA, and we're still in approval of the order that's being filed.
Thank you. Board, do you have any final comments before a vote? Mr. Moon?
I would move that we approve this order request for agency action.
I second.
All in favor, please say aye.
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 Any opposed? Please show it was unanimous. Thank you. Does anyone need a break before we start? We're good? Go on. Yeah. Does that need to be initials or Mr. Mayo, are you ready to proceed?
I believe so, Madam Chair. I don't see my screen up on the screen, but I think I'm all ready to go once I'm ready to go.
So we're not waiting on anything.
I don't believe so. I think
Okay.
we're ready. Thank you.
Okay. Moving on to docket item number 4. Docket number 2024-007, cause number 199-05, in the matter of request for agency action of Prichetti Energy Holdings LLC for an order requiring an accounting and payment of proceeds from the ARB Energy Utah LLC. This matter has been continued from the May 22nd, 2024 board hearing. Mr. Mayor, appearance of counsel.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner, in this case, Prichetti Energy Holdings LLC.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Tyler Cahoon with Denton's Durham Jones Pinniger, counsel for ARB Energy Utah LLC. And with me today is Mr. Joe Frost, President and General Counsel of ARB Energy.
Do we need to swear in some witnesses here?
I believe that's appropriate at this time. With us today is Dr. Mike Prichetti, the managing member of Prichetti Energy Holdings.
Mr. Prichetti?
Would you raise your right hand? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
And Mr. Cahoon, do you have anyone you'd like to swear in?
Yes, I have Mr. Joe Frost here. And additionally, we have an electronic witness that could be available. We did submit a motion for this late last night. There's been no objection by any of the parties. We're not sure if Ms. Meeks will be necessary, but we do want her available for the board if the board wishes.
Do you have any objections to her being sworn in?
The question was whether we had any objection to the motion, the question in the email, and we had no objection to the filing of the motion. Whether the witness is helpful or prejudicial at this point, if they're not sure she's even necessary for the testimony. We don't have a resume. We don't know whether she'll be giving factual or expert testimony. We don't know if she's here as the person responsible to respond to the subpoena or if she's here as, rebuttal testimony of some kind. So it's difficult to really know how we feel about it, to be honest. That being said, if there's a question the board needs an answer from and it can only come from Ms. Meeks, I'm happy to step aside, if that helps.
Division, do you have any objection to this person testifying?
Yeah, I'm in agreement with Mr. Mayor. I don't know the purpose of the witness, so until I know the purpose, I can't really object to why they're using the witness.
Should we clarify that before we start?
Ms. Garrison, if I may interject one thing really quickly. One thing that was unclear from the motion, the motion was filed less than 48 hours before the hearing, and in the rules, that's only allowed upon a showing of unforeseen circumstances. And I know those typically can be difficult to disclose, but the only allegation in the motion was that there were, quote, unforeseen circumstances. If there's some explanation as to why she can't appear or what she's here to testify about, maybe we can help satisfy the board's inquiries.
I think we're going to go ahead and approve the motion for her to participate. However, before she participates, I would like her to give a resume that gives some credence to her testimony.
We're happy to provide that, Madam Chair. She is
Okay.
the controller of ARB Energy, and so her testimony would be focused on any accounting questions the board may have. We do feel that Mr. Frost will be, he can be that witness as well, but in the event the board has additional questions for the company's controller, we thought it would be helpful for everybody involved.
Mr. Mayo? You good
Yeah, I
with
mean,
that?
to the extent that you know we're here the morning of the hearing discussing whether their accounting witness can or might be necessary in an accounting matter is a little bit upsetting. I've got to be honest. I'm sure Mr. Frost can testify eloquently as to what he thinks of the accounting, but I don't know that it's going to help us get to what Perchetti's been working so hard to get to here today and what the board deserves. So I have turned my non-opposition into a soft objection. Thank you.
Very well. We're going to proceed. We need to swear in the ARB, including Ms. Meeks, in case she does testify. Could you please stand? Hold up your right hand.
Same time or separate?
Same time.
Same time, okay.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
All right, Mr. Mayo.
I think.
To begin.
Thank you, Madam Chair. As has been mentioned, members of the board, Mitch Mayo of Lear & Lear PLLC. I'm appearing today on behalf of the petitioner in this cause, Perchetti Energy Holdings, which I'll refer to as Perchetti, most likely. With me today, who's already been sworn in to testify, is Dr. Mike Perchetti, a veterinarian from Elko, Nevada, who is the managing member of the LLC, who's entitled to proceeds. As Mr. Perchetti, who I'll refer to as Mr. Perchetti as much as possible, has already been sworn in, I'll move on. Based on the board's order granting motion for leave to file supplemental exhibits, which was entered on August 23rd, the exhibits we're going to present today were allowed to be presented and discussed at this hearing. However, the board reserved a decision as to their admissibility to the end of the hearing. So we will be discussing those. But I will, because of that order, be waiting till the close of our case in chief to move for admission of any exhibits that the board is interested or willing to admit in this hearing. At first blush, this case can seem really complicated and confusing. It is not. It is not confusing, no matter what ARB may tell you today, and no matter how many last-minute motions get filed. The RA before you is as straightforward as any you're likely to see this year. It is a simple and straightforward statutory accounting matter. This is not general civil litigation, and you are not a court in the state of Utah. You are an administrative body that was set up specifically by the state legislature and granted specific authorities to enforce. And that's what we're here for today. Jurisdiction. This board has jurisdiction pursuant to 40-6-5 and 40-6-9 sub 4. Additionally, so that the board doesn't have to worry about proper notice or due process, ARB Energy Utah LLC, the respondent and the only other party with an interest in this action, was duly noticed and is here today, has been afforded every opportunity to participate and respond. And with that out of the way, the factual background. Excuse me. Since January 1st, 2020, Perchetti has owned a 25% working interest in 125 wells operated by ARB Energy Utah LLC, which I'll refer to as ARB. Despite ARB receiving gross revenues from proceeds of production of nearly $13 million during this same time frame at issue, ARB has, without explanation, failed to pay Perchetti any proceeds of production. And Perchetti has asked repeatedly, in every way that's possible. Finally, at a dead end, and given ARB's repeated refusals to pay or account, Perchetti was eventually forced to retain counsel and to file the present request. In the face of a statutory accounting determined by this board to be necessary, ARB again refused to pay or account. During the division-ordered mediation and investigation, ARB alluded to participating meaningfully, and then went silent and failed to pay and failed to account. When the board held its hearing in March of this year on this very matter, ARB flat chose not to attend the hearing or participate. So the board was forced to take the highly unusual step of issuing a subpoena, and a subpoena ducis tecum, requiring ARB to produce documents necessary to complete the requested and statutorily available accounting. And 2, to attend this hearing today to answer any questions the board may have about the same. The subpoena, which was amended and may be referred to as the subpoena or the amended subpoena, was amended such that ARB's requirement to produce the documents was extended to May 31st of this year. ARB failed to produce the requested documentation by May 31st, choosing instead to produce only gross gas revenue information and only for approximately 1/2 of the relevant time frame. However, this represented, I must admit, the first time that ARB had substantively responded during this process. Finally, on July 3rd, ARB provided what it deemed a supplement to its initial production. However, for counsel in the room, this was in no way a supplement, as it was an entirely new set of production, covering different months and different years of production. But I digress. Regardless, after both sets of production are considered, it becomes clear ARB provided only gross revenues, and only those gross revenues related to gas. ARB did not provide any evidence regarding oil revenues, and ARB has not provided any of the relevant expense information necessary to justify the non-payment. As ARB has explained it in its flurry of motions in the last 2 weeks, its chief reason for failing to provide the expense information necessary to complete the required and demanded accounting is that the subpoena, and I'm generalizing here, didn't explicitly request it, and ARB had no idea they needed to provide it at this hearing. There are, as far as I can tell, only 2 possible reasons for taking that approach. The first, ARB is trying to avoid accountability by claiming ignorance. Or 2, ARB operates wells in Utah and does not know that expense information is relevant to the payment of working interests. Neither rationale should give the board any confidence that ARB is capable of or intends to comply with its statutory and contractual obligations to pay owners timely for the oil and gas that ARB produces on their benefit. And ARB has not explained itself, despite several invitations and a couple of legal requirements to do so. At no time has ARB filed a pleading responsive to the request, and no one, neither a party nor any member of the public, has filed a protest or objection. However, given that ARB didn't object or protest and didn't participate meaningfully in the investigation and negotiation phase, the board entered an order ending that phase of the process and setting this matter for today's hearing. Although the board had not received any responsive pleadings, the board did receive one public comment letter filed by and on behalf of Walter S. Fees Jr. and Son Oil and Gas LLC, which if I refer to it, I'll refer to it as the Fees letter. The Fees letter can be summarized as follows. I also own a working interest in wells operated by ARB, and despite repeated requests, I can't get proper accounting or payment either. For its part, Perchetti has tried everything in its power to move the needle. Despite all of its efforts and the board's involvement, Perchetti has been unable to get ARB to do its only job with respect to producing wells, sell the product, and divide the proceeds. Accordingly, the board has every reason it needs to enforce its statutory oversight in the clearest terms possible. And this is an important issue, not just for Perchetti. A determination that ARB has no reasonable justification for its delay in paying Perchetti serves 2 equally vital purposes. First, it obviously helps hold ARB accountable and provides Perchetti some much needed and much deserved relief. But second, and more broadly and more importantly, I would argue, it will send a clear and unmistakable message to all those entities in Utah that operate oil and gas wells that this board intends to ensure that they will be held to account for payments to those on whose behalf they produce. Now, that's a lot of information, but the board really only has to make 2 determinations here today, neither of which are complicated or really that close of a call. The first, I'd ask you to confirm a decision you made earlier in this process, that Perchetti is entitled to proceeds of production, and those proceeds have not been paid. To be clear, this is established in this case, and it's clear and uncontroverted on the record. and as far as I'm aware, ARB has not refuted Perchetti's ownership in any way, formally or informally in this. Second, after confirming that determination, you must determine whether ARB has presented here today, quote, reasonable justification, end quote, for its failure to timely pay Perchetti. Since ARB to date has provided no justification for its failure to pay, Perchetti and this board should be highly suspect of the reasonableness of any justification put forth here today by ARB. And with that, I'm ready to begin my examination, unless the board has a preference to the otherwise.
Please proceed.
Thank you. Dr. Perchetti, will you please start by stating your name and spelling your last name for the record, if you could?
Dr. Mike Perchetti, spelling is Perchetti.
Okay. And what is the current business address for Perchetti Energy Holdings?
The current address is the same as my resident address, 2921 Ruby Home Ranch Drive in Lamoille, Nevada.
Okay. And what is Perchetti Energy Holdings, and what is your current role with Perchetti Energy Holdings?
Perchetti Energy Holdings is an LLC that was set up to invest in oil and gas, mainly this investment that I made. I'm the managing member along with my wife, who is a member.
Okay. And as the managing member, do you, I assume, exercise a supervisory role or at least have access to and control over all the relevant documents related to Perchetti?
Yes.
Okay. You said this is Perchetti Energy Holdings is an LLC established to hold investments related to oil and gas. Would it be fair to say that you're not an oil and gas expert?
Yes, that would be fair to say.
Okay. Would you tell the board, if you could, give them just a quick minute or two? Who are you then?
Okay, I'm a father and a husband first, a veterinarian and a cattle rancher in Nevada. And third or fourth down the list, I'm a investor in oil and gas. And I want to show my gratitude for this prestigious board for allowing me to present my case and hear my story today. I realize that this board has a very critical role and is very important to the natural resources of the great state of Utah, and has a very busy schedule and didn't necessarily have to hear this case. And I do want to express my gratitude and my respect for the board. And I'm here to ask for your help. I've extended every other avenue possible that I could think of, and finally was forced into retaining counsel, and that's why I'm here today. I have got my, I guess my family, my ranch, and my veterinary practice have had real hardship over the last year and a half, especially because of this. I've had issues trying to come up with enough money to pay my income tax, and it all relates back to being in this predicament of not receiving my working interest revenue. I put a lot of money, basically was a really big part of my life's work into this investment, and it turned out to be a fantastic investment. There's been robust gas production and sales. I just ended up with a operator that has been really uncooperative and maybe ill-willed, if you would, and have not been able to get any response, no matter how I attempted to get some revenue coming my way, or even accounting, other than being able to get on the Utah website and see that there was gas and oil being produced, and at the end of the year getting a lease operating statement showing that they were selling gas and actually claiming that on my taxes as retained earnings, yet never receiving that revenue. I have paid taxes on some of that money and still have yet to see any of it. So I'm in a bad predicament, and I am pleading with the board to hopefully finally give some resolve and move on with my life and get some relief that my family is really needing at this point in time.
Thank you.
Yeah.
That's helpful. Board, I know there's been a hearing in this matter already, and there's been a bunch of filings, and there's a couple pending motions. Typically in a hearing, I would just proceed and go through my exhibits and present our case. Before I do that, I just wanted to check and see if the board had anything that they would like us to focus on or avoid, so that we can help kind of service the purpose of the board in this hearing. If there's no instruction, I'll proceed as quickly as I can through the exhibits in order.
I think just proceed. I have a list of questions here, but I'd like to hold them off until you're done with your presentation, and I'll ask them all at once. They're
Perfect.
sort of contractual questions.
Makes sense. Thank you,
Thanks.
Madam Chair. Okay, Dr. Percetti, I'm going to turn you now, if I can, I'm going to see if I can do it right, to what's been submitted and is being considered here today as petitioners' exhibits 1, 3, 7, and 8. And you can look up on the screen if you'd like. Might be easier to follow along. I'll try and guide you. Exhibit 1, Exhibit 3, Exhibit 7, and Exhibit 8. Do you recognize these exhibits?
Yes.
And were they prepared by you or by someone under your direction or supervision?
Yes, they were.
Okay. Board, Madam Chair, I'd like to point out one thing. With respect to Exhibit 1, these are, as far as we know, unadulterated copies of the assignments of record in the BLM and SITLA lease files, respectively. And there's also a copy of an assignment, a true and correct copy of the assignment recorded in Grand County, Utah. And so to the extent necessary, we'd ask the board to take administrative notice of each of these documents of record.
Thank you, yes.
Okay, thank you. Moving on, Dr. Percetti, I'm going to turn your attention to this Exhibit 1 that we're looking at here. It's several pages of assignments. Let me ask you first. These are a series of assignments that were attached to the request for agency action filed in this cause. Do you recognize these assignments filed as Exhibit 1?
Yes.
Okay. Can you tell the board, high level, summarize what these assignments represent relative to what we're here discussing?
These assignments represent, at the time it was 126 wells. I think there's 125 now that are still in production or shut in, that have not been abandoned, and approximately 76 leases on 34,000 acres, all in the state of Utah, and all of these assignments were purchased from Arb Energy Utah.
Okay. And when did you purchase all of these assignments or the interests underlying all of these assignments at the same time, or can you talk a little bit about that process?
Yeah, it took me some time to come up with all the money to pay for the entire 25% working interest, and I finally got the money, all to Arb in 2021, but the effective date on all the assignments is January 1st of 2020.
Okay. Turning your attention to what has been filed and was just shown to you as Exhibit 3, can you please tell the board what this is and confirm, I guess, that this identifies the 125 wells in which you own an interest?
Yes, that identifies the wells.
Okay. So to clarify, through the assignments identified as Exhibit 1, you acquired a 25% working interest in the 125 wells listed on Exhibit 3. Is that right?
Yes, that's correct.
And that's interest is effective January 1st, 2020 to the present?
Yes.
Okay. Were all of these wells identified on Exhibit 3, were they all drilled when you purchased your interest?
Yeah, they all had been previously drilled. Nothing has been drilled since I purchased my working interest.
So current production, existing production?
Existing production, yes.
Okay. The heart of the matter. In the 5 years, nearly 5 years that you have owned a working interest on the wells at issue, have you received any proceeds of production from ARB?
No, none.
Okay. Have you requested proceeds of production from ARB?
Yes, in every way that I could think of every way possible.
Okay. I'm going to turn you to what's been filed as Exhibits 4 and 5, and these are illustrative. Board, these are really summaries designed to kind of give a background from the record so that we don't have to comb through all of it. But really, it's Dr. Perchetti's going to testify about everything in here. Turning your attention to Exhibits 4 and 5, the board in prior hearings has repeatedly asked about the status of these payments and about also has inquired about your efforts to contact ARB for payment and our information about why payments weren't received. Can you talk about Exhibits 4 and 5 and how they answer those questions?
Yeah, we have just summarized basically some of the communication that took place between myself and ARB and, trying to find out how much revenue was being produced by the wells and when the revenue was going to start being paid to me. And, the board, I'm sure, is kind of wondering what kind of answers I received. And for the most part, it was probably pretty similar what the board, experienced dealing with ARB over the last several months. And, my attorneys have been dealing with me for the last 9 months now, is just lots of promises and never coming through with any accounting documents, just promises that full accounting and, consolidated reports would be done shortly and money was basically being retained and, there was lots of excuses and, probably the one date on there that stands out to me is just before, I decided I had to do something different. Is August 2023. I traveled to Grand Junction and met up with ARB and tried to, with Humberto to try and, get a idea of how we were going to, get a resolve. And at that time, it was going to be just a matter of weeks until I had $2 million coming my way. And here we are today, and I still have not received any revenue.
And just to clarify for the record, you mentioned Umberto. Is it fair that you were referring to Umberto Servant, one of the principals of ARB Energy?
Yeah, he's the one I dealt with the entire time for the most part. I purchased my working interest from him.
Okay, thank you. So Exhibit 4 is fair to say it's a summary of your attempts to try and get payment information or payments before filing the request.
Yes, yes.
Exhibit 5 is it fair to say this is a summary of attempts to communicate and get that same information from ARB since filing the request?
Yes.
Okay. Now, moving on to what has been filed as Exhibit 6. In this cause, again, members of the board, this is largely illustrative. This is already part of the record. However, it should be obvious looking at the screen. I've added some bright colors. Those are mine. Those are not part of the record. Those are just to give us, so we're all talking about the same language at the same time. Exhibit 6, I'm gonna walk you through this if I can. This is a copy of the amended subpoena ducis tecum and subpoena that's on file in this cause. In the subpoena, as you can see, the yellow highlighted language is the command. And if you could read that, I'll read it aloud so we're all on the same page. The board commanded ARB to, and I quote in yellow, to provide, and I quote, a copy of all records, books, documents, communications, or electronically stored information evidencing, and then it listed 3 different sets of things that it wanted produced. In blue, proceeds from sale of production from any well producing oil or gas in the state of Utah. In purple, it wants a copy of all records, books, documents evidencing payments of such proceeds. And in the orange, the board requests a copy of all records, books, documents, etc. for, quote, any other associated or relevant information regarding payment of proceeds. Before we get into discussion of the amended subpoena, you testified earlier that you own a working interest, Dr. Perchetti. Is that right?
Yes.
As the board is well aware, as a working interest owner, you are entitled to a share of production, but you also are required to pay your share of the costs attributable to that production. Is that your understanding as well?
Yes, yes, and I also realize that, and am very concerned with the amount of liability that the working interest owner takes, and another, added stress to this situation without any revenue to, be available. That liability could be very detrimental to me financially.
Absolutely. It's fair to say then that as a working interest owner, you believe that, for example, documents evidencing any allowable deductions would constitute, quote, any other associated or relevant information regarding payment of your proceeds?
Absolutely, 100%.
Okay. Now, turning to what's been submitted as Exhibit 7. This, again, Your Honor, can be disregarded if the board would like. This is merely illustrative. It's a summary from Perchetti's perspective, absolutely, of the production to date from ARB. Dr. Perchetti, it appears that, and we've alluded to the fact that ARB has complied in part with the amended subpoena. Can you tell the board about ARB's partial compliance? Talk about it real quickly for them.
Yeah, I don't know if we mentioned it here, but they did not submit anything to the first subpoena, and then right at the deadline, May 31st, they did produce partial revenue statements showing some gas and gas sales, and I don't think there was any oil sales records in there, but and there was also an objection to any other information that they may have that may be proprietary, and which caught me not being an attorney. I thought that was not just kind of goes in along with them refusing to be very cooperative, because as a working interest owner, I own these wells just as they do, and I feel I am entitled to know exactly how much these wells are producing and how much it costs to produce gas from them. And they objected to the board subpoena about that, and then basically failed to provide what was requested of them on May 31st, and then about 5 weeks later in July, just around the 4th of July, they produced some more documents.
Okay, and that July 3rd production, when you say they produced some more, is it fair to say they didn't produce everything?
Yeah, they did not really give us anything that we requested to try and determine what type of expenses we should be deducting to determine the amount of revenue that I'm entitled to.
Okay, so when all of ARB's production is considered in this case, when all of their responsive documents are considered, essentially they provided gas revenues for all months for as requested, but failed to provide oil revenues or accounting documents as well.
Yeah, I did see, the gas revenues were complete. They had, every single statement by the month, who bought the gas, how much was paid for the gas, and how much was sold. There was one statement in there for oil sales, but essentially nothing else. But yeah, the gas revenue was very complete.
Okay, thank you. So with the gas revenue complete, the only information you or the board needs at that point is the accounting, the expense information. And ARB never provided this documentation. I'm going to turn you to what has been filed as Exhibit 8 in this cause. Can you please tell the board why was this exhibit prepared in the first place?
Well, this is the information we asked ARB to provide for, basically Perchetti Energy Holdings. They submitted everything that was, shown for ARB Energy Utah as another working interest owner, but nothing was submitted directly towards what Perchetti Energy Holdings was entitled in the way of revenue. So we, basically took all the numbers that they provided, the month by month, made a spreadsheet, and put it into a summary here with the very top box showing the dollars that traded hands and went from the gas purchaser to ARB's pocket, to ARB's bank account. And then, the second box, in my opinion, is the very most important here, because the, over $3 million there at the top line, that is the, based on the revenue that ARB provided, that they showed us on their revenue statements from the gas purchaser, exactly the number of dollars that were taken in by them that were directly dollars that were for the sale of Perchetti Energy Holding gas. The dollar amount every month was, basically 25% working interest is, that $3 million is 25% of the 12 in the upper box. So that shows exactly the amount of money that they received from selling my gas.
Let me hop in and make sure we're all following, if that's okay.
Yeah.
So the top box, as you just said, is essentially your reorganization of the gross proceeds information that ARB submitted to you.
Yes, exactly.
Okay, and the total gross revenues ARB's claiming during the relevant time frame is just under 13 million. Is that right?
Yeah, and that was up through February, I believe, 2024.
Okay, that's right. You started to talk about option 1 and option 2, the two boxes at the bottom. Given that there is an expense information, there's really no way to do an accounting. Option 1, it sounds like you said, and tell me if this is correct, it's essentially a calculation assuming the board says, ARB, you had the ability to bring forth evidence of costs and you didn't. Perchetti's entitled to payment on gross proceeds. This is what option 1 is. Is that right?
Yes, that's right, and probably the most just number there, really, because there was a contract that said, yeah, I own this gas, I paid for it, I own the working interest. They were selling my gas, putting the money in their bank, earning interest on it for the last 4.5 years now, never, turning over any of that, essentially stealing my money for 4.5 years. And that's why the center box, the two numbers in red are the statutorily, available, penalty and interest on this money that I feel I am entitled because of the damage and suffering my, entities, my family and my other businesses have gone through over the last, years of not receiving this.
That's right. So option 1 then is essentially if the board were to say you get 25% of gross revenues, option 1 would be the box they would pay attention to. Understanding you're a working interest owner and you're responsible for costs regardless of ARB's failings, is it fair to say option 2 is assumed costs to deduct from your revenue?
Yeah, we figured, that even though there wasn't any contracts in place in the way of JIBs or AFEs, nothing was in place. There wasn't an official executed JOA, so it's hard to come up with exactly what expenses would be deducted if everything was in place. So we tried to come up with a number that the board could look at and say that this is absolutely the lowest number based on taking out the highest number of, our highest expenses per well. And we did that by looking at, we were able to find one JOA that another working interest owner had that, is basically governing 58 of the wells that overlap. Mitch mentioned Walter Fees earlier, and he's been a working interest owner since these wells were drilled by his father, I believe, in the 80s, 70s, and 80s. And he still has the last JOA that's relevant that we could find, and it was submitted. We got it from him. ARB did not submit it, but it was signed by all working interest owners at that time, and it calls for, allowable expenses of $300 per month per well. It's dated, 1996, I believe. So to try and come up with a number, we then did an informal evaluation of a bunch of current JOAs in the state of Utah, most of which were from working interest that over existing wells that are long lateral, 2 and 3 mile laterals. So, which operational expense on a well like that, I could see where would be a lot more on a monthly basis than a gas well that flows gas and has for the last 40 to 50 years, requiring very little, month-to-month maintenance. So we came up with a number of $1,000 per well per month, which ends up happening to be, what was on those JOAs that govern the working interest that covers those big oil wells. So these gas wells should be much more efficiently run. So if we use that number, we thought that the board would be able to see that as a very bottom number that Perchetti's entitled to.
Okay, let me see if I can unpack that really quickly. So you have access to a JOA that you have no certainty is binding on you from the 80s, and that JOA only calls for $300 in monthly expenses allowable. Is that right?
Yeah, it was dated in 1996, I think.
96,
but either
thank
way,
you.
it was dated. But
okay, and
we
so
did
then
not
you
use the 300 either. We
that's right.
Used 3.3 times that much to account for any other inflation essentially and higher expenses that may occur.
And just to clarify, you got that from a review of JOAs currently in place for long lateral horizontal wells and standard overhead allowable under those JOAs for existing producing wells.
Yeah, the $1,000. That's what the JOAs we reviewed had.
With that, really that's the entire presentation to you today, board. We feel like our job is to help orient you and then answer any questions. And so at this time, I will turn Dr. Perchetti and myself over to ARB or to the division or board for questions.
Board, do you have any questions? I've got several.
I have a lot of questions, but I think I'd like to hear the whole presentation, both presentations before.
Okay.
Madam Chair, we do have questions for Dr. Perchetti. Would it be okay if we asked him some questions now, or we're happy to answer them or ask them later? We'll defer to what the board wants.
Mitch, are you?
Yes and no. Right? Dr. Perchetti is a factual witness, and to be abundantly clear, we don't have a burden here today. We don't have anything to prove. It's not our job. It's their job. So to the extent they need to question him on those things, I'm happy to consider that.
Can I respond? Madam Chair, can I respond to that?
Yes.
They've just proposed taking gross revenue from ARB Energy. We vigorously dispute and disagree with that, and we would like to cross-examine Dr. Perchetti on this Exhibit 8.
I think the board would like to hear your rebuttal here before we ask our questions, to hear both sides first.
Mm-hmm.
So proceed, Mr. Cahoon.
So proceed with cross-examination or proceed with their presentation?
Questions on your presentation.
Okay, so they're going to proceed with their presentation now. Is that right?
Yeah. Okay, so I'm proceeding with my presentation.
Yes.
Oh, yeah. Mitch, can I borrow that cable from you?
Yeah, I'll run it over.
I might need to borrow that from you in a moment. Okay.
Before we start, I have sort of a blank page here for exhibit presentations. And so as we're going through, I need to note these, and Julianne will also note these.
Thank you, Madam Chair. We will have some rebuttal exhibits that we will move for admission. And
okay.
I will hopefully identify those properly for you to jot down.
Thank you.
In the table.
Madam Chair, it's probably appropriate time just to make sure that everyone's clear. There is a pending motion for admission of these out of time, and I just didn't know if the board wanted to rule on that or hear them first before they decide.
When we do have we do have objections to Exhibit 8.
Okay, let's
to reserve.
This is getting very confusing here with what we're doing. You've made your presentation. You want to ask questions on their presentation. Now, are we considering that the rebuttal or just questions?
And I think that's what we're
Okay.
headed for, Madam Chair. But the problem is their
Okay.
presentation is based on exhibits that were filed this morning at 7:45. I haven't even had a chance to open yet, so I just want to note for the record the extreme prejudice, and then allow everyone to proceed.
Okay, let's proceed with ARB's presentation.
And I'm happy to address that. Thank you, Madam Chair and members of the board. My name, again, is Tyler Cahoon. With me today is Mr. Joe Frost, General Counsel and President of ARB Energy. We are appreciative of the board taking this matter today and taking the time to hear our side of the story. You just heard Mr. Mayo's presentation of ARB, and we have a vastly different perspective of the backstory of this matter. And I just want to make clear that ARB is fully transparent, and we are willing to answer any question that the board, the division, or Dr. Percetti has. And we hope that is going to be the theme throughout the relationship going forward. I just want to make clear also, Mr. Frost and I got involved in this matter in late spring, and we helped to respond to the subpoena. We've had numerous discussions with Dr. Percetti's counsel, both local counsel and lead counsel out of Texas. We've tried at length to resolve this dispute with Dr. Percetti, but we have been at odds on the amount that is owed to Dr. Percetti. And there is a lot of disagreement about that, and it has been, from our point of view, impossible to resolve with where Dr. Percetti has landed. The scope of the hearing today, we understood from the board's May orders and the recent August orders that the board is concerned about were payments withheld and whether there was reasonable justification for withholding those payments. The answers to those questions are very simple, and Mr. Frost and I will address those in a moment. We do object to petitioner's late disclosed Exhibit 8 on several grounds and grounds that we raised in our motion that was filed before the board. This hearing should not be about a complete accounting as contemplated by Utah Code 40-6-9. That could be addressed at a later time by the board. The issues before the board today is whether there was payment withheld and reasonable justification for the non-payment. On those questions, the answer is yes for three main reasons. There was reasonable justification for non-payment. Number one, there is no signed JOA, joint operating agreement, between the parties, even though the parties expressly agreed in their agreement that they would execute a joint operating agreement to govern their relationship. Second, Dr. Percetti has signed no division order. And under Utah Code 40-6-9, one of the enumerated reasons for withholding payment is when a person entitled to payment has failed or refused to execute a division order. That has happened here. And Mr. Frost will explain later that because Dr. Percetti has refused to execute a JOA, ARB has not sent out division orders to be signed. And so there is no signed division order here. Third, petitioner is seeking an unreasonable and unjustifiable amount from ARB, as shown on their Exhibit 8. They're claiming to be owed gross revenue. Or in the alternative, they are claiming to be owed net revenue of estimated expenses, neither of which is justifiable. They own a 25% working interest of ARB's and a 25% net revenue interest of ARB's. That's it, and no more. Neither the law nor the agreements justify any more than that. And we do have several objections. And for those reasons, for those three reasons, and Mr. Frost will get into this a little later, we request that the board find that there was reasonable justification for withholding payment and not impose the penalty allowed under the statute. We will have several objections to Exhibit 8. Namely, it's incomplete, it lacks foundation, it's not relevant to this proceeding. It's outside the scope of what the board is considering today, and we do not believe it should be considered. Petitioner's argument that we submitted these rebuttal exhibits this morning and they'll be prejudiced, it's a little disingenuous because they did file their exhibits, which this Exhibit 8 is quite detailed and very impactful, 3 weeks late. And we have been scrambling day and night to refute the numbers in that spreadsheet, which we are prepared to do today, but in our minds should not have to do today. They will not be unfairly advantaged by the introduction of our exhibits later. The rules expressly allow rebuttal exhibits to be presented at the hearing. There is no obligation on the respondent to disclose those rebuttal exhibits before the hearing. We did provide notice to counsel, opposing counsel, and board counsel before the hearing as a courtesy notice. Exhibit 8 assumes that Dr. Percetti is entitled to 25% working interest in numerous wells. That's not the case. Dr. Percetti was assigned a 25% interest in ARB's working interest and net revenue interest in the wells. The exhibit also does not account for ARB's actual gross revenue. Instead, Dr. Percetti used part of ARB's data, created its own spreadsheets, plugged in its own numbers, estimated amounts, and then deleted the formulas under which they arrived at their numbers. The exhibit also does not account for ARB's actual operational expenses, which were provided. The numbers were provided in our response to the subpoena. The backup for those numbers was not provided because there is a dispute on the reading of the amended subpoena. In our minds, the subpoena did not request expense information, but I want to make clear that we are happy and willing to provide that information as soon as possible to the board, to Dr. Percetti, to the division, to review and arrive at a number. Exhibit 8 suggests two options, again, neither of which have merit. The first one, Option 1, it says to assume no deductions and Dr. Percetti is owed 25% of the gross revenue. That's not what the parties agreed to. So he can't ask for more. The second option, he asks you to assume operational expenses. And he has looked at other joint operating agreements informally to arrive at that number. That is not justified. We have provided the expense numbers that for whatever reason they refused to address in their Exhibit 8 spreadsheet. And as Mr. Frost will identify later, we have backup numbers backing up the expense information, and we're also willing to provide all of the backup information for the expenses. ARB is willing to pay Dr. Percetti the correct amount, but not the unjustifiable number that Dr. Percetti is requesting. Petitioner is attempting to extract many multiples of what he is actually owed, and he's using an incomplete accounting to arrive at that number. Now some responses to petitioner's presentation regarding ARB's partial productions to the subpoena. That's not true. There was no partial production. In responding to the subpoena on May 31st, we provided responsive documents and responded with an objection to the subpoena. That is typical in any litigation to object and respond to a subpoena. Notwithstanding those objections, we disclosed relevant information. We also reserved the right in that objection and response to supplement any disclosure. And this goes against the story that Percetti is saying, that we have been unresponsive, we don't want to disclose anything. If that were the case and we found that we had other responsive documents, we wouldn't have responded on July 3rd. That's not the story. We are willing to be open here and transparent, and that's why we supplemented our disclosure after an inadvertently did not include documents responsive to that subpoena. Also, there's no gross revenue detail on oil, as council identified, because the wells at issue are not oil wells. Generally, any liquids are extracted from gas streams at a third-party processing plant and accounted for on their monthly statements. And one other thing to make clear, Dr. Percetti has not been waiting for a payment since January 2020. This is because the transaction assigning the interest to Percetti was actually consummated in April 2021. That's nearly a year and a half later, and that will be important in determining the amount owed. In conclusion of my presentation, before I direct Mr. Frost, again, ARB is transparent and willing to resolve this matter with petitioner. They have tried at length to resolve it. But Dr. Percetti has refused, unreasonably and unjustifiably. We have worked in good faith. We've been responsive to the parties, and we understand and acknowledge that ARB was initially not responsive in this matter. But as you can see today, we are here, we are willing to answer questions, and that will be the case going forward. ARB had reasonable justification for withholding payment because of the refusal to enter into a JOA that the parties agreed to, because they have been unreasonable and unjustifiable in the amounts they're demanding, and because of the lack of a signed division order. It appears the petitioner wants the board to punish ARB and therefore get a windfall for what petitioner did and not agree with the JOA that he agreed to enter into. We respectfully request that the board order that there was reasonable justification for non-payment and that proceeds, and there was reasonable justification of non-payment of the proceeds and no penalty is warranted. ARB requests that the board order a full accounting under its authority under Utah Code 40-6-9 to determine the number owed to Percetti, or accept ARB's rebuttal information based on actual numbers rather than the made-up numbers in Dr. Percetti's exhibit. I will, if there's no questions for me, I'll turn to direct Mr. Frost now, if that's okay.
Please proceed.
Mr. Frost, will you please state your name for the record?
Joseph Frost.
What is your relationship with ARB Energy?
I'm the general counsel and president.
How long have you been with ARB Energy?
I joined in February of this year. I did work for ARB previously and then took about a 9-month break and went and worked for Tesla for a few months and then came back this year.
How long have you been in the oil and gas industry?
Since 2003, so 21 years.
Okay. Are you familiar with ARB's accounting and financials?
Yes.
Do you work closely with the controllers and CFOs and executive team on those?
Yes, every day.
Okay. Let's turn to the reasonable justification for non-payment, Mr. Frost. We identified 3 simple answers. 1, that there was no JOA, 1, that there was no signed division order, and 3, that Dr. Percetti has been unjustifiably unreasonable. Will you please tell us about how the parties agreed to enter into a JOA at the outset of their relationship?
Yes. So a purchase and sale agreement was signed prior to the closing of the transaction back in 2021. And it explicitly states that the parties agree in that document that they will enter into a new JOA to govern the relationship between them. Shortly after closing, I wasn't here at the time, so this is all my understanding, but...
Objection to this testimony to the extent that he has no actual firsthand knowledge.
Thank you. We're going to proceed.
At that time, the parties started discussing the terms of the joint operating agreement as well as bonding requirements. As you know, the state requires significant bonding for this number of wells. And Mr. Brachetti was unwilling at that time to enter into a joint operating agreement. And so the parties almost immediately got into a dispute situation, and they went back and forth with each other. We were trying to get a joint operating agreement signed. He refused, didn't like the terms, wanted to change provisions that typically are not changed in joint operating agreements. As the board may know, almost all operating agreements are the AAPL form, which is exactly what we were trying to do, was put in the AAPL joint operating agreement. And so immediately the parties were at odds with each other. And without a joint operating agreement, you don't have the ability to calculate exactly what a party is owed, a working interest owner is owed. Without a joint operating agreement, you don't have a division order. And at that point, you know, there were various attempts over time to restart conversations and negotiations, but they went nowhere in each instance. I think Mr. Cahoon is pulling up the purchase and sale agreement between the parties that will specifically state that a JOA was supposed to be signed.
Technical difficulty. Excuse me. Another reason not to get a Mac. Do you have this?
He has this.
Can you zoom in my screen? Yeah, okay, I guess we can zoom in.
So, let's see what we have here. Let's go ahead and plug you in.
I got it.
Is this your presentation right here?
Yeah, if I can pull up that document.
Are you running Windows on a Mac? Yeah, then we may need to switch. Yeah.
Sorry, no, we're good. I got the other one. Back that up.
Yep, this is it. Yep.
Okay. So this is what we will identify as petitioner or respondent's rebuttal exhibit 1.
Objection, Your Honor, this doesn't rebut anything. This is the absolute information the board requested and was requested in the RAA, and I have to object. This doesn't rebut anything.
So noted. We're going to go ahead and look at it because we've never seen the offer to purchase before. Thanks.
Okay. So, Mr. Frost, do you recognize this document?
Yes.
Can you articulate what this document is?
This is the purchase and sale agreement entered into between ARB and Mr. Perchetti pertaining to the assets at issue.
Okay. On the last page here, do you recognize those signatures?
I do recognize Mr. Servent's signature.
And you'll see that signature at the bottom. By whom?
Mr. Michael Perchetti.
Okay. I'd like to refer you to section 1 of, or no, I'm sorry, it'll be section, getting there, section 7 of the agreement, Mr. Frost.
Yes.
Will you please read that provision for us?
All operations on the properties shall be conducted pursuant to the terms of a joint operating agreement, JOA, which shall be executed by ARB and MP at closing.
Was there a joint operating agreement that was ever executed among the parties?
No, there was not.
Will you please tell the board and the parties here today how that has impacted ARB?
Well, without a JOA, we really don't have the ability to correctly set up our internal decks in our accounting system to lay out which party is responsible for which costs and expenses. I mean, we have the general, I mean, for the most part, these things are very standard from one to the next, but there can be some differences, as well as overhead is one of the specific things that was brought up by Mr. Perchetti's counsel. And so without that specific document in place, it's really impossible to know exactly what to pay. And without a division order in place, it's typical not to.
Will you please explain the negotiations between the parties on the JOA?
We presented a joint operating agreement, the standard form. There were objections and misunderstandings as to what charges would be passed through to Mr. Perchetti's company, and things quickly just devolved from there into I'm not signing it, and that pretty much ended the conversation for a substantial period of time.
And has that resulted in the status quo today?
That is correct.
Okay, on the second point for reasonable justification that there's been no division order signed, will you please tell us why, from your perspective, why no division order has been signed?
It just goes back to the same thing. Since a division order lays out specifically the obligations and rights of the parties with regard to payment of monies, and without a joint operating agreement to spell that out, then we don't have that certainty in order to put together a correct and appropriate division order.
If there was a joint operating agreement agreed to, how would that impact the relationship between the parties?
At that point, we would be able to set up what we call our decks in the accounting system to create joint interest billings that were accurate and correct, send those out, and we probably wouldn't be here at this point in time.
And if Dr. Perchetti was in those decks, would ARB send out division orders to be signed?
Yes, we would.
On the third reason for justified reasons for withholding payment, will you please explain to the board how ARB has tried for several months, even years, to be reasonable with Dr. Perchetti in addressing the payment dispute?
So there's no doubt that over the years, both Mr. Perchetti and Mr. Servent have reached out to each other at different times to try and resolve the dispute between them. Mr. Perchetti did provide detailed dates of opportunities that they've spoken. I can confirm that they did speak multiple times over the years, and in each instance that I'm aware of, they came to a resolution. Like, they actually talked, worked through things, had an oral agreement that was
Objection.
back.
This is his summary of a conversation between two other people that occurred years prior to him even working at the company. I request this be stricken.
Let's move on, Mr. Frost.
Okay. I'll just say that they were never able to come to an agreement and put it into writing.
Objection.
So noted.
And I would just respond to the objection that rules of evidence are guideposts in this proceeding, and the rules for the board today should be construed liberally in getting to the speedy, just resolution of the issues today. And so we would like it not to be stricken so we could get the fast, speedy resolution of this matter. Okay. Coming back up to this same rebuttal exhibit 1, Mr. Frost, I'm going to highlight this section that I want you to read here. Will you please read that highlighted section for us?
For the avoidance of doubt, the parties stipulate and agree that the interest in the properties to be conveyed to MP by ARB under the terms of this agreement shall be 25.0% of ARB's working interest and net revenue interest in the leases and wells as reflected in Exhibit A and Exhibit B.
Okay, in reviewing Dr. Perchetti's proposed Exhibit 8, does it accurately reflect what the parties agreed to?
No, there's multiple issues. First of all, it's 25% of ARB's working interest and net revenue interest, not a 25% working interest, which in most instances in this case is not a big amount because ARB owns the supermajority of the working interest. However, it is just a key point that it is of ARB's interest. And then secondly, Mr. Perchetti is only entitled to 25% of the net revenue interest from production. So For example, Exhibit 8 did not include even royalties. It didn't include taxes. It didn't include any operating expenses. In his second option, if you will, it had a assumed overhead rate, but that's just an overhead rate that's in a JOA under the COPUS accounting mechanism. That's not actually the cost of operating the wells. So any actual costs incurred would be on top of that $1,000, if that was the right number, which I don't know that it is, but it's probably somewhere close. It would be on top of that $1,000 number.
And Madam Chair, I know the board's inclination to hear the evidence. I'm happy to say that. I'd like to note for the record, in case of appeal, we have the assignments that flowed from this offer letter, and no court in the land, and this board shouldn't either, would interpret the offer letter when they have the documents of record, the actual assignments in hand. That's what governs title, not the offer letter. And with that clarification, I will be quiet.
Thank you.
And I would just note for the record for appeal that ARB owns working interests and net revenue interests, and those assignments assigned those interests to ARB. And so the assignments at issue are consistent with the purchase agreement. What I'm showing you, Madam Chair, members of the board, is marked as Rebuttal Exhibit 2. Joe, do you see this on the screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
Did you assist in preparing this document?
Yes, I did.
Will you please articulate for the board what this spreadsheet is and how it impacts the issues today?
So we took Exhibit 8 that was produced by Dr. Perchetti. The column in D are the numbers that he put as the Perchetti provided. I put that title. Perchetti provided gross revenue numbers. Those are the numbers that were in the same column of his Exhibit 8 that you saw earlier. We then went into our accounting system because we couldn't tie his numbers to what we had provided previously. And so we wanted to figure out what the actual numbers were for the same time periods. One thing I will note for the board is you'll see that for 2024, I highlighted in red, that's his numbers were through February of 2024. Since we now have accounting records through April that have been closed, we did include the green numbers are through April, not just through February, to provide a more complete picture for y'all today. So we went through the actual accounting books and records of the company and wrote in column E the actual 8's gross revenue net of taxes that was received by ARB Energy. And you'll see those numbers vary slightly, and then they get a little bit bigger. In 22 and 23, we actually are reporting significantly more gross revenue than Dr. Perchetti's numbers came up with. Then we took and in column F put in our net revenue share of those gross revenues. So this is the actual amount of money that ARB, under its working interest as 100% owner before Dr. Perchetti, would be entitled to. Excuse me, that's incorrect. This is the number after the sale for Dr. Perchetti, how much we would be entitled to. And then we put the expenses in column G. Column H has Dr. Perchetti's 25% NRI share of all revenues for each year. And then in column I, it has his share of expenses. And then in column J is the net income that he would be due under the assumed provisions of a JOA.
And these numbers are not estimated numbers?
No, these are all actual numbers from our accounting system, which we'll talk about later. We have a full accounting system for it with backup for every single number that went into these. None of these numbers were just typed in, for example, or made up off of summaries. well, they're summaries from the actual accounting records, I guess is what I'm trying to say.
Madam Chair, I must object to this. This is not in any way, shape, or form a rebuttal exhibit. This is a blatant attempt by ARB to skirt the rules and its obligations. This is the accounting. This is the accounting that the request asked for, that the division asked for, that the board asked for at the first hearing, that the board subpoenaed. This is not a rebuttal exhibit, and to allow it to be considered this morning at 7:45 allows ARB to completely thumb its nose at this process and get in front of you the exact information that it has for some reason been hiding from all of us for 8 months and can only supply as a rebuttal the morning of the hearing. I strenuously object to the inclusion of this evidence here today, as we haven't looked at it or had a chance to review it after months of requesting it.
May I respond, Madam Chair? Thank you.
Mr. Cahoon, do you have a comment?
Yes. To be clear, our reading of the amended subpoena that was issued to ARB did not request expense information. And to the argument that it's not a rebuttal exhibit, it is a rebuttal exhibit because they've proposed in Exhibit 8 certain numbers that we want to rebut, and that's what we're rebutting. And the fact that it was presented at 7:45 this morning is allowed under the rules. I will read you Rule 641, 105, 500, exhibits. Any exhibits intended to be offered by the parties in rebuttal of evidence presented at the hearing will be presented at the hearing.
I think at issue in this hearing is whether or not the proceeds were justifiably withheld. And in that context, this is not an accounting hearing. And so we are not going to allow this exhibit at this time.
I'm sure maybe you could flesh out what procedure you envision. Is there additional hearings after this that the board would consider and request, I guess, them to supply documentation to be at that hearing to consider? Is that the next step?
This has been a very confusing issue on, how to proceed. I think we're going to have to discuss it among the board exactly what we anticipate out of this hearing and should there be additional hearings. But we're not talking about an expense situation here. We're saying, were they reasonably withheld? That's the question today. So I can't tell you right now if we'll require additional hearings or how we're going to proceed. We need to listen to the information from both sides and discuss it among the board members. Thank you.
Thank you.
For the record, Madam Chair, I think we would make the same objection on Dr. Perchetti's Exhibit 8. If this proceeding is going to be about reasonable justification, their Exhibit 8 should not be admitted as well. And if the board wants to address numbers and expenses at a later proceeding, we are more than happy to appear at that hearing and provide any information necessary. Yeah, I'm going to clarify.
Okay, to be consistent, I guess we are going to withdraw Exhibit 8 for purposes of this hearing.
That makes sense, Madam Chair. I do have to question, though, what exactly the purpose of this hearing is, because as I understood it, and I could be wrong, there's already been a hearing in this cause where this board determined that there was no justifiable reason for pay. So there is obviously a purpose to confirm that here on the record, and that's important. but the board specifically requested expense information and asked them to show up with it and defend it here today. If not to do an accounting, I'm not entirely certain what that purpose was.
May I respond, Madam Chair? We have not seen in the record where the board has requested us to present expense information today. The only reason we brought this information today was to rebut Petitioner's Exhibit 8.
Hang on just one second. I need to confer with counsel. We're going to need to confer among the board to give you good direction on where we're going. So we're going to step out for maybe 15 minutes and discuss it and see if we can see where we are.
Thank you. Anything
Thank
you can
you.
do. Appreciate it.
Thank you.
Thank you so much.
We are back on the record. We have decided we want to hear the rest of your presentation. However, we don't want any financial presentations at this point. We only want whether or not it was justifiable that this money be withheld. And so if you would like to proceed and finish your presentation, we would appreciate it.
One comment from me, if I may.
Sure.
Though we don't, want to hear the financials and that, as you had started to discuss, I would love to add that we would consider any other relevant information in the subpoena to include expenses and financial data as a key component. Is that fair, Madam Chairman?
Yes, that's fine.
Thank you, Madam Chair. I think we're pretty close on the conclusion of our presentation if we are not going to get into the financials, which we respect. I would just reiterate that reasonable justification does exist. There clearly is a contractual disagreement on the existence of a JOA and a resulting lack of division order, and from our perspective, the unreasonableness in Dr. Perchetti and wanting something that he's not justifiably entitled to. I think Joe can articulate what ARB is willing to do to help further this matter along. If you want to articulate a few things, Joe. Mr. Frost.
All right, thank you. If I just back up for 1 second, during the last hearing that I guess occurred in March, I was not involved in that. I didn't even know the existence of any of this hearing, this process or whatever. And so I do want to state that, ARB recognizes that it did not participate appropriately at that point in time. We did not have anyone within the company that was capable of that or aware of it that I can figure out. So I don't know how that happened, but I want to emphasize that we're here to engage right now and going forward. We're doing everything that we can to provide information. We would welcome from the board a subpoena if you want to, or an order that says that we need to provide all financial data. It's prepared, it's ready. It could be delivered today if it needed to be. We would welcome the opportunity to have a forced mediation to get a JOA put in place. We'll welcome any opportunity to provide any information that you or Dr. Perchetti needs. At this point in time, we're committed to participating fully in this process and bringing it to a conclusion.
And I think we would just request that the board find that there is reasonable justification for non-payment and not issue a penalty. And we conclude our presentation.
Thank you.
Thank you.
Thank you. Division, do you have any comments at this point?
Is this before you're going to start questioning or provide questions? You like to kind of get out input? Sure. This matter originally came to the division, as we've mentioned, because Mr. Perchetti filed a request for agency action indicating that he had not been paid proceeds. The division, upon board order, investigated this matter. They had 60 days to do that with ARB and Mr. Perchetti. We've heard this before. Mr. John Rogers was involved in these discussions. We've indicated previously that we got very little response, if any, from ARB. We were unable to come to a negotiation, and that's how we ended up before the board. During those negotiations, the division was never made aware of a JOA issue. The division was never made aware of an unsigned division order. These would have been helpful reasons to know why we are where we are now. But we were given nothing. We were never given financial information. We were never given any kind of, we saw a letter agreement. Division was not privy to any of this information or provided as part of our negotiations. As far as the division's role now, because we're past that point, we're past the point where the division is trying to adjudicate this matter between the parties. We have a statute. We keep repeating it, 40-6-9, and under 40-6-9-1, a working interest owner is entitled to payment of proceeds within 180 days of first production or 30 days after sales after that. The only exception to that is unless there is other arrangements, unless other periods or arrangements are provided for in a valid contract with persons entitled to the proceeds. I've heard nothing today why payments weren't made. I've heard that we're waiting on a JOA, we're waiting on a division order. I haven't heard why exactly these payments were not made within that time frame, and if they weren't, again under the statute, were amounts placed within an interest-bearing escrow account? Because that is what the rule requires ARB to do. We can proceed with the questioning of the respondent and the petitioner as we go forward, but that's the petition, that's the division's view here, is we have a statute for a reason, and why were these things not met? And the division doesn't have an answer for our part in this process. Thank you.
Thank you. Board, do we have any questions right now?
Is your estimate of net proceeds in an interest-bearing escrow account?
No, sir.
Okay, Mr. Mayo, back to you.
Yeah, given the kind of moving procedure here, I just want to clarify. I assume we're at the part where it's essentially you're asking me if I have any cross-examination questions of Mr. Frost related not to the expense information, but solely to their claims of reasonable justification. Is that where we're at, Madam Chair?
I think where we are. This is, we have figures from them, we have figures from you.
Both of which are being disregarded at this hearing.
And we could not determine at our level which of those would be correct. We believe the subpoena included all relevant data, which would include expenses, even though it didn't say expenses, in order to calculate a net revenue interest or a net proceeds interest, you have to have the expenses. And I think where we are now is they have presented some information just almost instantaneous with the thing, which you have not had a chance to review. I think our request is we have a few more items on the docket today.
Sure.
We would like you to convene with counsel for ARB and see if some of these issues can be resolved.
Madam Chair, I'm going to take what I will say openly is the first time I've ever taken this position in response to a court. My client and I have no interest in trying to settle this with someone who has ignored our legal requests for years. They will not settle this case with us, Madam Chair, and I want to be as respectful as I can. To be honest, delayed determination of reasonable justification so that we can attempt to settle it is essentially denying our petition. And that's within the board's purview. If the board wants to do that, it may.
And
May I respond, Madam Chair?
yes,
We have sent settlement offers over to Dr. Perchetti, and he has been unreasonable in his demands. And to the fact that counsel suggests that we are not going to settle this matter is quite insulting to us when we are trying here. Joe and I have been trying here since, late spring when we got involved to resolve this matter.
Madam Chair, I don't question their intent. We're at the hearing, and they still can't tell us what amount he may be owed. There's no reason to negotiate against a question. So to settle that is impossible until they tell us what they think he's owed definitively. And being bound by that, we have no counterpoint to that if the board can understand where we're coming from.
but did they not provide you a summary of what they believe they owe him? Today?
I don't know. Was that included in the filings today? Because I haven't had a chance to look at them. They didn't download on my phone. They were too big. They were Excel files. I was driving to this hearing when they came in, so I don't know that for to be clear.
I guess that's what Madam Chair is saying. It is late. It is late. We thought we asked for it. We understand there could have been some confusion, but they're there now. They're on the record. So, can we take an hour or two?
They haven't been admitted, to be clear. They're not on the record yet.
Right.
Just to clarify.
But we can say, well, they're open. They're
Right.
You can see them. So we feel that there would be some benefit to having some discussions for an hour or so until we complete the other matters, and then come back and.
If the board would like to delay this, I'm happy to. The one thing I would ask before that is that the board take the time to make the determination as to reasonable justification. It is unfathomable to me, as someone who represents primarily operators before this board, that in any accounting matter on behalf of Moon Energy Holdings against Crescent Point Energy, that this board would stand up at this point in the proceeding and say, Mr. Moon, can you try and resolve this? What have you done to get your payments? I can't see that. And I'm happy to take an hour and try and review what they've sent over lunch. I'm happy to try and do that so the board can move on. I know there's a docket here, but Dr. Perchetti's entitled to be on this docket as well and to be heard. So I just want to alert the board that I have very, very, very low hopes for that settlement. I'm happy to engage in it at the board's request, so long as we come back on the record and the board is willing today to make a determination as to reasonable justification.
I think we can do that. And did you make written offers to resolve this with Mr. Perchetti, or were they verbal?
Yes, there were written offers. I will defer to Mr. Frost on other negotiations that I was not involved in.
There was one written offer of which I'm aware recently, and given, as Tyler pointed out, that this board's lax relationship with the Utah Rules of Evidence, if the board would like to see what that is, the board has it within its purview to request and have that, and I'm happy to provide it. I'm sure Tyler is as well.
Were there written offers as to a JOA or just a settlement as of some date in dollars?
There were dollar amounts exchanged. As for a JOA, I'll defer to Mr. Frost.
There has not been any written offer for settlement on the JO issue in some significant amount of time.
And I would like to point out that the board ordered the parties to mediate in its May 24th order, and that was right around the time Joe and I got involved. And so, we reached out to counsel and wanted to get a mediation on the books. We entered into a letter agreement that Dr. Perchetti and the principal of ARB Energy would meet together and try and resolve it. There were discussions, there were deal terms that were proposed. Ultimately, those negotiations have stalled at this time, but it just shows that since Joe and I have been involved, we're trying to wrong the right here, or right the wrong, any wrong that has been here, and move this matter along.
Madam Chair, I'd like to point out to the board, if the board is interested in seeing that written settlement offer that was submitted 2 days ago, or it was on Friday of last week, I believe, they will see that ARB's reasonable and good faith settlement offer is lower, significantly lower than what they put forth today as the actual proceeds he's entitled to without interest and penalties. There is no reasonableness. There is no actual meaningful ability to make that decision here today, but I'm happy to do it to manage the board's docket.
So let me respond to that real quick. The written offer was for an amount within $10,000 of the amount that Perchetti is actually owed that would be consistent with our spreadsheet. And so to say that our offer was multitudes below what Perchetti is actually owed, Perchetti's actually owed about $500,000, and that was about what was offered to Dr. Perchetti.
Madam Chair,
we would like to see that offer if you could provide it to us.
I'm happy to. If the board would like, I can try and pull it up now.
We have no objection.
Yeah, if not, we can do it.
Yeah, that would be fine, so we could look at it.
Give me 1 minute, and then Tyler, if I could plug back into that thing, if you guys can. Thank you. Madam Chair, it might take me 5 minutes if that's okay. If not, I'm happy to do this.
Yeah, that's fine.
So while we're waiting, Mr. Perchetti, why was there not a JOA agreed to? Why didn't it happen? Were there specific terms that were different from the AAPL standard form, or?
No, it seems like I'm the only one in the room that was present during any JOA negotiations, and if Joe was informed by Humberto that he provided me a JOA, it is absolutely false. I have never seen a JOA that they have provided to try and, agree on.
Yeah, I'm talking back at the beginning. Back at the beginning.
Back in the beginning.
Your agreement said that before closing, a JOA will be signed.
Yeah, and I was
I
not
put it on both
prevented
parties.
for that.
Why did either party exchange money and leases without a signed JOA?
I traveled to Houston just for that purpose, to try and get that JOA, and I was not allowed to even see a copy or presented for any kind of a JOA. It never happened, and I requested it.
Let me clarify something for the record really quickly. These are producing wells that have produced for 40 years. There is a JOA that's applicable. We don't have it because we don't operate, and they've refused to provide it. What ARB was trying to do in the offer letter was get new JOA terms forced, which is fine. They have not provided new JOA to review. Plain and simple.
So there are JOAs in place that are enforceable?
If not, they've been operating, and their predecessors, illegally, at least without any of the information they say they need to get division orders, to suspend payment, to do anything. So absolutely there are JOAs in place. In fact, the fees letter references his JOA from 1990 something, Lone Mountain something. We just don't know which one's applicable because we don't operate. We cannot get that information. We cannot agree in principle with someone else. It's their job as operator.
And this is maybe a question for ARB. Prior to your execution of leases to Perchetti, were you covered by a JOA? Was that 75% covered by a JOA with other non-ops?
To first respond to council's contention that we didn't provide the JOAs, we did provide 30 applicable JOAs to lead Texas Council, Perchetti's lead Texas Council.
I'm not affiliated in any way with Texas Council, to be clear.
And then with respect to the JOA question, I'll defer to Mr. Frost.
Apologies, what was the question again, please?
Before you assigned those leases to Perchetti in 2020, this deal, was there an active JOA that covered your interest?
There are approximately 30 JOAs that cover the various wells that were and remain in place between us and the existing non-op working interest owners.
Okay, but there were JOAs in place?
Correct, approximately 30.
Okay, thank you.
Madam Chair, I got that email.
May I ask one other question pertinent to those JOAs? Again, I know we're not talking absolute sums of monies here, but your estimates of costs that would be attributed to these wells, were they based on the JOAs, those 40 JOAs that already were in existence pertinent to the wells?
That is correct. Yeah, and these JOAs were provided to Mr. Perchetti's counsel. The fact that his two lawyers haven't spoken, I don't know why that is, but those were provided already.
Again, another of Dr. Perchetti's failings in making sure he gets himself paid
So
properly.
if those JOAs are standard JOAs, do you feel like you would be comfortable agreeing to those terms?
Sorry, as a legal matter, there are contracts that bind these parties already. Without knowing the terms of those contracts, it's really difficult, if not, I would say incredibly unfair, to ask Dr. Perchetti to agree to different terms that he hasn't seen and has no idea. So I understand that there is some desire, it was expressed in the March hearing, to kind of put some of the blame on Dr. Perchetti to find this information out. I want to be abundantly clear. No operator in the state of Utah gets to defer its responsibility to the people on whose behalf they produce. Period. He may not have tried as hard as he could have to get a JOA. He is not required in any way, shape, or form to get a JOA. They never came in and pooled the interest, which is the alternative if someone is unwilling to agree to a JOA, and they've made so many good faith, reasonable negotiations about it, it would have been easy for them to have come in and pooled this interest and have accounting procedures assigned relevant to this. They didn't do that. Right? They now, at the 11th hour, are willing to be transparent if we'll only kick it a couple more months, and then they promise this time.
So I would respond that if the board were to take that argument into consideration, that would excuse any party from a contractual obligation into entering into a JOA. So if my wife and I enter into a JOA and we're both obligated to effectuate a JOA like we've agreed to, the burden's not all on me. It would be a joint responsibility, and that's what we're saying here. There's been a dispute among the parties, a contractual dispute that has resulted in this, and that needs to be resolved before payments can be made. And we're willing to explore JOA terms with Dr. Perchetti and counsel. We're willing to resolve this. I would like to make clear that Mr. Frost does have a flight that he does have to catch. He has to be at the airport at 1:30. He has doctor's appointments tomorrow that have been scheduled. But he is, ready and willing to come right back up here for any other hearing that's necessary.
This question is a general question for you, Mr. Mayo. If there is an existing JOA in any general circumstance, and I have a JOA that I've signed, I'm not going to sign half my interest to somebody else. Is that interest I sold not covered by the existing JOA? Do you always require the new owner to execute a JOA?
Well, no, and I don't require it ever. But the clients I represent, the experience I have with it is this. A joint operating agreement is a contract to govern operations of a particular well. Once you have that contract in place, unless there's a reason, if the well stops producing and there's a new well drilled, then a new JOA may be required. But unless that contract stops working for some reason or has a gap that needs to be filled, once you've contractually agreed how you're going to handle the well, you don't need to agree a second time or a third time just because someone else takes over. In fact, most assignments, and I'm assuming the assignment and bill of sale that you have as Exhibit 1, include catch-all language that you take subject to all existing contracts and agreements, et cetera.
Thank you.
You're welcome.
Madam Chairman, could I ask a question of ARB?
Let me just interrupt for 1 second. I understand you have to leave, but we are unable right at this moment to make a decision. Mr. Cahoon, I assume you will be here and can speak for ARB.
Yes.
Okay.
Before that happens, Madam Chair, just to clarify, we did have a couple just obvious cross-examination questions of Mr. Frost. So procedurally, anyone who has questions of Mr. Frost, if we're going to let him go, we might want to ask those before we rely on counsel to answer them.
Can Mr. Borden ask his one question, and then we will?
Please, absolutely.
And I realize you weren't the person involved several years ago, but this is just a question for ARB in general. When there wasn't an agreement on the JOA signing, which was one of the key requirements for that contract for the 25% to be finalized, was there any talk internally about maybe we should just, this deal has fallen through, we should return the monies to Perchetti and, agree to go our separate ways? Or was there any talk of, well, we will pay out what we think we owe him every year, to try and just keep it fair rather than you're holding the money, he gets nothing over the last 4 years?
Things were apparently very contentious for quite some time. Both parties were refusing to talk to each other for a very long period of time based on the contention between them. And but to answer your question, I am not aware of any discussions that took place until recently where there was just a discussion of, hey, let's just give it back, undo the transaction, and everybody can go back to where they were. I'm not aware of any of those until recently.
Thank you.
Again,
But
just
you're
for
saying there were some discussions of that recently.
There were, yes.
Okay.
But not with this gentleman, with Texas Council.
not relevant to what you're doing, but I promise we're working on it with someone else.
That's not what I'm...
Mm-hmm. Sure. Did you say you want me to ask my questions now? Okay, well, thank you. Appreciate the board narrowing this hearing a little bit. Reasonable justification should be fairly easy to get through quickly, and that's really all we're focused on. Dr. Perchetti's entitled to proceeds. They have not been paid. The only issue is whether there's reasonable justification put forth, and ARB put forth 3 things as reasonable justification. First, there's no signed JOA. Second, as a result of the no signed JOA, there's no division order. And third, they've tried to be reasonable in settlement, but Dr. Perchetti has not. With that refresher, Mr. Frost, I'm going to ask you just a couple questions. You mentioned you have you're testifying as a fact witness, not an expert witness in this hearing. You haven't been qualified as an expert, but you have significant, as you testified, experience in oil and gas and expertise that comes with more than 2 decades working in the oil and gas industry. Would you agree with that?
Yes.
And ARB is, as you've said numerous times here today, transparent and responsible operator who's trying to do the right thing. That's fair, right?
We are.
Okay. So as someone with a lot of experience in oil and gas, would you say that it is Dr. Perchetti's responsibility to prepare a JOA, or it is the operator's responsibility to prepare a JOA?
Generally, the operator prepares a JOA. However, it is the responsibility of both
just
parties.
Yes or no's perfect.
You
already had explanation. This is just the yes or no part.
The document says that we both have an obligation to enter into one, and it takes 2 parties to sign that document. And that's the problem, is that we can't get the other party to sign the document.
Thank you. So you obviously then have evidence here today, I'm assuming, of those communications where you sent, or excuse me, you didn't work here until after all these shenanigans took place. But what ARB sent as a JOA, you have the copy of that you can show to everyone here today to justify that, or is that something you'll need to send to us at a later date?
I do not have that, and I don't know whether I would be able to get that.
Okay, so you don't have any evidence whatsoever to back up what you heard about a JOA being sent?
I don't know whether that's accurate either. I have not gone through my computer system.
Okay, today you could not say you have evidence to back it up.
I have no evidence with me today.
And thank you. So there's no JOA in place. Obviously, you've said there are 30 plus JOAs that apply. So there are JOAs in place, just not the JOA that ARB wanted. Is that right?
No, it's not the JOA that Mr. Perchetti wanted. We would have preferred to use the existing JOAs in place, and that was apparently not the deal that was struck. We would have a separate JOA put in place between the parties.
And again, this is based on your understanding of conversations. I'm assuming there's documents you can provide to the board to back up these stories.
I do not know.
Okay. So again, just trust me. Now, you testified also that the JOA is a predicate. You can't possibly prepare a division order without a signed JOA. Would you explain to the board, based on your experience in oil and gas and ARB's proficiency in operating, what exactly about not having a JOA prevents you from sending out a division order?
I am unable to intelligently speak on that. I'm sorry.
Okay. So let me speak on it. I don't know if it'll be intelligently. A division order, as I understand it, lays out a record working interest and has nothing to do with any contractual agreements that are made. Wouldn't it be fair to say that regardless of a JOA, nothing prevented ARB from sending out a division order that recognized the record title it had assigned? Is that fair?
No.
Okay. So ARB was prevented, uniquely prevented in a way you cannot intelligently articulate here today, from sending a division order because there wasn't a signed JOA.
That is what we're saying, yes.
Okay. Thank you for that. Madam Chair, let the record reflect, if it will, JOA in no way implicates a division order. They're not related or required to be in tandem. The third point that I would like to ask, and really just kind of hit on a little bit, you testified earlier, yes, he's entitled to money. Yes, he's entitled to a significant amount of money, right? Over $500,000, as your counsel pointed out. Not a small amount. Yes, we've known about this for years. No, we have not escrowed that money. Can you provide any explanation to the board as to why ARB chose to flout that rule? Why it chose not to do what it was supposed to do when it had a question about payment and suspend that in an interest-bearing account? What was the justification?
I don't have any justification. I don't know any facts surrounding it.
Okay. So, Madam Chair, members of the board, what I think we're seeing here is a pretty clear example of I know the answers I want to know, and I struggle to know the answers that are tough. With that, I'd like to just hit on one other thing in response to what was said. He has a working interest. Dr. Pache has a working interest in leases that produce.
May I redirect first?
This is.
Are you done with my witness?
Oh, no, not at all.
Okay.
No, yeah, one more. One thing that Mr. Frost testified about is that they produced oil revenue information. That's fine. Clearly we missed it, and clearly that's not at issue today, but I'd ask the board to simply take administrative notice of the publicly reported oil and gas production on these wells. We can all figure out what that means in terms of dollars at a later date, but the truth is whatever was produced has been publicly reported, and I just ask the board to take administrative notice of that in light of Mr. Frost's testimony about the oil proceeds.
Thank you. So noted.
And with that, I'm done with my questions for Mr. Frost.
I would just have a couple redirect questions, Madam Chair. Mr. Frost, the documents we do have reflecting the transaction between these parties, we have a purchase agreement, correct?
Correct.
The purchase agreement has a provision in it saying the parties will execute a JOA at closing, correct?
Correct.
The JOA was not entered into, correct?
Correct.
Dr. Perchetti has refused to engage in executing a joint operating
Objection,
agreement.
Tyler.
Correct.
Just to clarify, is this bill of sale? Is this part of the exhibits that are part of this record?
The bills of sale.
You're quoting language from a contract that I'm not sure anyone in this room has seen besides you and Mr. Frost.
The contract is rebuttal exhibit 1.
Oh, perfect.
Yeah,
Thank you. So it is
rebuttal
of
exhibit
record.
1.
That's
I'm
all. I
sorry.
just wanted
So
to make
rebuttal
sure.
exhibit 1, section 7 requires a joint operating agreement to be entered into among the parties.
Yes.
That wasn't entered into.
Correct.
So there is a contractual dispute among the parties at the
Correct.
core of this case.
That's right.
And in your mind, has ARB been reasonable in trying to resolve this matter with Perchetti?
Yes.
Why?
Why? I mean, So I can speak very intelligently about the part since I've been involved in the last 6 months. Prior to that, I don't have as much information to tell you except for what I've been told about the process.
Madam Chair, on that basis alone, I would like to object to his entire testimony in the record. His last 6 months is none of the time period that's relevant, and he just said on the record definitively, I can't speak intelligently to anything that's happened before I got there. Why are we...
That's not what I said.
It's a mischaracterization of the testimony.
I misunderstood. I apologize.
Look, my understanding of my position here today is to be a company representative, to represent the voice of the company to this board. And that's what I'm trying to do the best that I can. I don't know everything. I relied on other people's discussions. I relied on other documents that aren't here today. And I'm doing the best that I can to tell you what I do and don't know.
Okay, one more question. Utah Code Section 40-6-9, subsection 8 says that there's an enumerated justifiable reason to withhold payment, and that says the person entitled to payment has failed or refused to execute a division order. Has Mr. Perchetti refused to execute a division order in this case?
He has either failed or refused, yes.
No further questions.
Division, do you have any comments at this point?
Just one. Mr. Cahoon indicated that he would like the board to order a full accounting to determine the amount owed. Is that correct earlier?
Correct.
Just from the division standpoint, we've heard testimony here today that ARB does not know the amount owed to Mr. Perchetti because there is not a signed JOA or an executed division order. If we did a full accounting, how could the division determine what is owed Mr. Perchetti without a signed JOA? What would be your hope there? If the board was to issue a full accounting, how could we come up with a number?
Well, I think we could run the numbers between gross revenue numbers and expense numbers, and then determine the value owed to Dr. Perchetti.
I think we would have to rely on the existing JOAs for what expenses are permissible under those JOAs. For example, overhead, monthly overhead on a per well basis, we'd have to rely on the existing JOAs in order to do that, and that's what we've actually done in preparing the summary that we have, or not the summary, but the detail we have already done.
And so would you be able to provide those documents that we would need to rely on to look at that information?
Yes, sir.
Okay, so just so my understanding is correct, and tell me if I have this wrong, we could come up with an amount that Mr. Perchetti is owed under your agreements, but you have been unable to pay him an amount because of an unexecuted JOA. Is that really what the argument is?
I mean, the argument is that there's a contractual dispute between the parties about a document that governs the payment of monies, and so those monies have not been paid while that dispute's been ongoing.
And your argument is that that contractual dispute fits under an a reasonable justification for non-payment.
That's correct.
Okay. No further questions.
I have one more question. If your interest, this goes back to my discussion with Mr. Mayo, was covered by a JOA, I understand you'd probably like all these under one JOA rather than 30, but isn't his interest already covered because it came from you who are governed by a JOA, which has probably gone through several owners over the years? Isn't his interest already governed by a JOA, even though it may not be the one that you would prefer, that either party would prefer?
I think we would have to rely on the contract, and the contract says the parties would execute a new JOA to govern the relationship.
Thank you.
The contract also said they would pay proceeds of production.
Testimony here. Are we done with the discussions to this point? Can we break at this point and reconvene? We'll continue until later this afternoon. We have 2, possibly 3 shorter items after lunch.
I'm happy to stick around, and we'll do the best we can to discuss if the board is saying recess.
And we will continue to discuss this over our lunch break and see if we can come up with a solution. At least a different path, right?
Perfect. Do you have any sense, you're going to, if you can give us a heads up on time in case we do go somewhere and want to come back so we're not delaying the proceedings?
2 o'clock, do you think? 2 o'clock.
Yeah, and don't expect all the solutions to come from us. We're hoping for some solutions
Right.
from you guys.
Understood.
So
Luckily, the statutes are clear, so we got lots of solutions
Yeah.
to choose from.
Lots of choices.
That's right.
Are we planning to include the other
Yes.
two? That's awfully ambitious for 3 more things.
2:30?
3?
Well, that's okay. I won't hold you to it. We'll head back between 2 and 2:30. And
Yeah,
plan on
just to
being
be safe. I don't know how long these other issues will take.
here. I didn't know if the board was going to take
So
lunch.
who's
or-
buying lunch between you two? You figured that out?
I think
It's going to be a 5-year legal battle, but we'll pay for it.
Nothing,
They'll
nothing
get
with
us back
tomatoes.
eventually.
Rick's paying.
okay. I think it'll just be me from our side
Okay.
this afternoon. I'll do the best I can to.
As long as you
Push
can
things
speak for the
along.
company.
Yeah.
All right. We are off the record until, let's say 2 o'clock. Might be late, slightly later than that, but let's try.
Off the record in this matter, or the board is taking lunch break?
Lunch break.
Okay, and this matter is continued till
Continued
later.
until 2 o'clock this afternoon.
Thank you, Madam Chair.
We are back on the record. Going to finish up our afternoon docket here. We're moving on to docket number 5. Docket number 2024-043, cause number 130-34. In the matter of the request for agency action of OVINTIV USA Inc. for an order modifying the board order entered in cause number 139-150 by extending the board's orders entered in causes 600-03 and 600-05 to reduce the north-south drilling unit boundary setbacks from 330 to 100 feet for the drilling unit comprised of sections 1 and 2, 4 south, 3 west, USM, and 2, establishing an overlapping drilling unit for drilling long lateral drilling unit boundary wells for the production of oil, gas, and hydrocarbons from the lower Green River Wasatch, comprised of sections 1 and 12, sections 6 and 7, 4 south, 2 west, USM in Duchesne County, Utah. Mr. McDonald.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Division.
Assistant Attorney General Gary White on behalf of the division, and I'm here with division experts Regina Echo and Colton Goodrich.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today, appearing virtually pursuant to the board's August 16th order, are Mr. Ashley Ellison, the senior land negotiator. Mr. Ellison, thank you. Mr. George Jennings, the geologist. George, if you'd wave. Thank you. And Mr. Christopher Wall, who's the reservoir engineering advisor. Mr. Wall, thank you. I would ask that they be sworn in at this time.
Can you all raise your right hand? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. I do.
Madam Chair and members of the board, the resumes of all 3 witnesses were submitted collectively as Exhibit A. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Ellison will be a fact witness only in this matter. Mr. Jennings and Mr. Wall have previously been recognized by the board as experts in geology and petroleum and reservoir engineering respectively times. Based on their resumes and their previous recognition, and presuming the division has no objections, we request that they be recognized as experts in those particular disciplines for purposes of this cause.
No objection.
So accepted.
Thank you. And as been my practice, I will be moving for admission of the exhibits as a whole at the end of our presentation in chief.
Thank you.
Members of the board, today OVINTIV is before you seeking approval of a 2-part request. First, OVINTIV seeks reduction of the heel toe, which in this case is the north-south setbacks, from 330 feet to 100 feet for the drilling unit comprised of sections 1 and 12 of Township 4 South, Range 3 West in Duchesne County. This drilling unit was established under the board's 139-150 order, and the setbacks we're requesting were we're asking through extension of the board's orders in 600-03 and 600-05, which the board allowed the reduction of the setbacks in nearby areas. As the testimony will reflect, such reduction not only results in additional resource recovery that would otherwise be left in the ground, but also does not adversely affect the correlative rights of the production interest owners in the adjacent lands for at least 10 years and only minimally, if at all, thereafter. As I previously noted, the board has granted such relief in the 2 orders, the 600-03 and 600-05 order, as well as in other areas of the basin. And this is the trend that's being requested by nearly all of the operators with respect to long lateral horizontal well development. Secondly, OVINTIV is seeking establishment of a drilling unit boundary well drilling unit comprised of sections 1 and 12 of 4 South 3 West and adjacent sections 6 and 7 of Township 4 South 2 West, with authorization to drill up to 5 wells within the 100-foot heel-toe setbacks and up to 330 feet flexibility along the boundary line between the 2 existing 2-sectional drilling units, and with the same additional caveats as the board's existing drilling unit boundary well orders contain. This, too, is similar to relief that the board has previously granted on several occasions, including the 600-05 order. True and correct copies of the 139-150, 600-03, and 600-05 orders were collectively submitted as Exhibit B. Since Indian mineral lands are involved in the drilling unit boundary well drilling unit, A communization agreement is required, and the agencies, whether under federal guidelines or by practice, require a spacing order of the board for such communization agreement to be approved. This is another reason why OVINTIV is before you today. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested drilling unit boundary well drilling unit, to working interest owners, including unleased owners, in the established drilling units adjacent to the affected areas due to the requested setbacks, and to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and the Vernal Field Office of the Bureau of Land Management due to the tribal ownership, and also to the Utah Department of Transportation and the Division of Forestry, Fire, and State Lands due to state ownership. The mailings were sent to these parties at their last addresses disclosed by the relevant agency and Duchesne County Realty records. In addition, the notice of the filing of the request and this hearing was duly published in the Deseret News on August 2nd, 2024, the Salt Lake Tribune on August 4th, 2024, and the Uinta Basin Standard on August 7th, 2024. On August 12th, 2024, the division filed a response expressing no opposition to the granting of the request. No other objections or responses to the request were timely filed, and nobody else is making an appearance here today. With that, I'll commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. I'm a senior land negotiator for OVINTIV USA, Inc. Our address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And you are the landman responsible for these drilling units at issue?
That is correct, sir.
All right. Would you state for the record OVINTIV's corporate and bonding status, please?
OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operation in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is a successor by name change to Newfield Production Company in merger of OVINTIV Production, Inc.
Mr. Ellison, I'm now going to show you what have been marked as Exhibits C through I for purposes of this hearing. They're shown on the PowerPoint. I believe you also have them in front of you. Do you recognize these exhibits?
Yes, sir, I do.
And were they prepared by you or OVINTIV personnel with your review and input?
Yes, sir, they were.
Turning your attention to Exhibit C, would you please explain to the board and division what this reflects?
No problem. Sections 1 and 12, the DSA of the DSU shown in red. That's the Dutchman, we'll call the Dutchman DSU is in red. It requests a drilling unit boundary. DSU is in both red and blue, so the drilling unit boundary will be between those red and blue DSUs. The area is bisected by US 40 east of the Bridgeland community.
Now turning your attention to Exhibit D, this is a 2-page exhibit. Starting with page 1, would you please explain what this shows?
Sure. These are the zoomed in plats of sections 1 and 12, where the heel toe setback reduction is requested in the proposed drilling unit boundary. DSU is requested. So this section 1 and 12 is the Dutchman DSU.
Right. So this is the one where you're asking for the setback reduction. Let's go to the second page then. This is the drilling unit boundary well.
That is correct. So the Dutchman is the 1 and 12, and the Ella DSU is 6 and 7, and the drilling unit boundary will be between them, please.
All right, thank you. Turning your attention now to Exhibit E, would you please explain what this reflects?
Yes, sir. So there's one existing horizontal lease line, long lateral horizontal well within sections 1 and 12 of the Dutchman DSU. And then there's one existing long lateral horizontal well in the Ella DSU and 3 existing vertical wells. And those vertical wells converted in sections 6 and 7 once we drilled the long lateral horizontal.
Now turning your attention to Exhibit F, this is a 2-page exhibit. Starting with the first page, would you please explain what this shows?
Yes, sir. Sections 1 and 12 of the DSU are under 130 is under the 139-150 order. These are just the status of the existing spacing orders on that area. Sorry, I should have mentioned that before. Sections 6 and 7 are presently under the 139, 150, and 605 orders. The 605 are reduce the heel toe setback. And then sections 5 and 8 of 4 South 2 West is an internal drilling unit boundary DSU established under 605 order.
All right, and then the second page just shows the status of those drilling unit boundary well orders. Is that correct?
Yes, that's correct, sir.
Okay, and then so 6 and 7 and 5 and 8 constitute a drilling unit boundary well already under the 605 order.
That is correct.
All right, thank you. Now turning your attention to Exhibit G, would you please explain what this reflects?
Yes, sir. So this is a plat of the current setbacks in the present orders. So sections 6 and 7, 100-foot setbacks were established under order 605. In sections 1 and 12, there's currently a 330-foot setback under order 139, 150.
And finally, turning your attention to Exhibit H, would you please explain what this shows?
Yes, sir. So this is the gross working interest in the subject lands. OVINTIV, you can see, is the clear majority working interest owner for these DSUs.
All right, and are there Indian minerals located within these drilling units at issue?
Yes, sir.
And what is your experience with respect to the requirements of the federal government with respect to Indian minerals in drilling units?
Sure. You know, OVINTIVs, in my personal experience, when Indian minerals are involved, a spacing order not only facilitates but is required for BLM and or BIA approval of a conforming communitization agreement, whether by guidelines or actual agency practice.
Okay, and finally, turning your attention to Exhibit I, please explain what this shows.
Sure. This is an illustration reflecting how the notice was provided. The dark purple area, we notified all production interest owners were notified, so all working interest owners and all royalty interest owners. The lighter purple is the area where we notified all working interest owners, including unleased owners, in the established drilling units adjacent to the DSUs as issued. And that's due to the requested setbacks.
All right, I'm now. Oh, go ahead.
Yep, go ahead. Sorry.
Okay, I was going to refer you now to the certificate of service, which is a pleading already on file here that was prepared by my office. Do you have a copy of that in front of you?
Yes, sir.
All right. Could you please explain the names and addresses and how they were derived on that document?
Sure. Yeah, these are all names that were, their parties and addresses were compiled from OVINTIV's internal land records, including title opinions and a search of the BIA, Forest Service, and Duchesne County records prior to filing the RAA by Lone Wolf Energy, Inc., which is OVINTIV's contracted land service company.
Okay, just to clarify, not the Forest Service, but the state forestry, fire, and state lands. Is that what you meant?
Yes, sir, that is correct.
All right, thank you. For members of the board, we sent this out regular mail, so there's no certified mailings or an Exhibit Z that you're used to seeing on that. With that, that concludes my examination of Mr. Ellison.
Division.
No questions. We had a few, but they were cleared up in the direct. Thank you.
Board, do you have any questions for this witness? Mr. Moon.
So why is this the lease line or the cross townships? Is it because of other abutting larger DSUs?
Mr. Moon, I guess.
Yeah. How does this fit in with other?
Sure. It's my understanding that we did not initially, these lands were not included in the most recent order 600-05. You can see the green and Exhibit 5.1 was a more comprehensive reduced setback drilling unit boundary order.
Mm-hmm.
This area is kind of the area that in flux, I guess, of where the engineers want to lay down the DSUs or stand them up. So at the at the time that we initially did 600.05, we didn't necessarily know definitively if we wanted to include sections 1 and 12 in that or not. This DSU is going to be drilled relatively soon. So we would like to include it now that we have more information on current wells that have been drilled in the area.
Okay. You are comfortable, though, that this will fit in with other DSUs, large DSUs?
Yes, sir, that's correct.
Okay.
In a perfect world, we would have included it originally.
Okay.
And then we would have saved some time.
Any other questions? Mr. McDonald.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Jennings. Mr. Jennings, would you please state your name and address for the record?
Hello, yes. My name is George Jennings. I work at OVINTIV USA, Inc., and I'm located at 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And you're the geologist that's working these drilling units at issue?
That's correct, yes. I'm a development geologist working the Uinta Basin.
Okay, I'm going to show you what have been marked as exhibits J, K, L, and M for purposes of this cause. Do you recognize these exhibits?
Yes.
Were they prepared by you or OVINTIV personnel with your review and input?
Yes, they were.
Turning your attention to Exhibit J, would you please explain to the board what it shows and its significance to today's hearing?
Yes. On the left-hand side, we have the Shell Brotherson 1-11B4 type log, which illustrates the stratigraphic definition for the lower Green River to Wasatch transitional formations. So that has kind of the basin definition for what those are. And then we have the application lands highlighted on the map with a red square and shown relative to where that type log is located.
And what do you try, or what are you trying to show there with the highlighted light green on the log?
Yes, that's reflecting the primary intervals, which will be targeted in these DSUs.
Now turning your attention to Exhibit K, would you please explain what this shows and its significance to today's hearing?
Yes, this is a correlative log of the primary targeted intervals for the long lateral wells that we will be drilling here. And this well is located within the DSUs in the Ella DSU there. And you can see that there's 5 primary targets that are highlighted in this exhibit.
And this also shows the cross-section that you're going to discuss in the next exhibit?
Yes, the pink line on the map illustrates the cross-section we'll be examining in the next exhibit. That's correct.
Okay, turning your attention now to Exhibit L, would you please explain what this shows and its significance to today's hearing?
Yes, this is a cross-section going through the area of interest. Really what we're highlighting here is the uniformity throughout the area. The formation tops are very consistent. And this just illustrates that the lower Green River to Wasatch transitional formations constitute one common source of supply in this area and are consistent with the board's designation of those formations as one pool throughout the Uinta Basin.
And now turning your attention to Exhibit M, would you please explain what this reflects and its significance to today's hearing?
Yes, this is a maximum stress map. So you can see in the blue circles with the black arrows, those are maximum stress indicators that we've directly observed in wells. And you can see that in the DSU in question, we have a maximum stress going east-west or roughly east-west. And if we take and look at all of the wells that are on here, we can see that on average in this area, we have a north 74 west maximum stress. And this indicates that we should in fact drill this DSU as a stand-up DSU from north to south.
Okay, and just to the significance of the starred well there, That's the PVT data that's used by Mr. Wall in his exhibits. Is that correct?
That is correct. Yes, the red star indicates the what he will be using.
All right, thank you. Is it your expert opinion, therefore, that the uniformity and thickness make the lower Green River Wasatch an attractive target for longer lateral horizontal drilling?
Yes.
Is it also your expert opinion that the fracture orientation supports stand-up drilling units?
Yes, it is.
Finally, is it your expert opinion that the lower Green River Wasatch constitutes one common source of supply in this area?
Yes.
Madam Chair, that concludes my examination of Mr. Jennings.
Division, do you have questions?
No questions, thank you.
Board, do you have questions? I think we're good. Let's proceed.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, name is Christopher Wall. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
What is your current position with OVINTIV and its relation to these drilling units?
I am a reservoir engineering advisor working the Uinta Basin with jurisdiction over these DSUs as well as others for OVINTIV.
Okay, now I'm going to show you what have been marked as exhibits N, O, P, and Q. Do you recognize these exhibits?
Yes.
Were they prepared by you or OVINTIV personnel with your review and input?
Yes.
Turning your attention now to Exhibit N, would you please explain to the board what this shows and its significance to today's hearing?
Exhibit N is a reflection of the Exhibit N is a diagram of a horizontal wellbore with the 74-degree northwest fracture orientation, and around that, the hydraulic fracture of 110 feet is a dashed oval there that represents the drainage area and shows that there will not be any drainage of adjacent lands with the requested setbacks of 100 feet.
Now turning your attention to Exhibit O, would you please explain to the board what this reflects and its significance?
So Exhibit O is the Hales and Evers drainage calculation. It's a methodology previously deemed acceptable by the division and the board. The parameters from the well are from the subject well on Exhibit L, which is a Uteland Butte well. What this is showing that there's no drainage of adjacent lands at 5 years, and there'd be minimal, if any, of drainage of adjacent lands at 10 years and beyond.
Now to Exhibit P, please explain what this shows.
Exhibit P is the oil in place EUR and recovery factor summary. And what it's showing is that the average oil in place is 298 million barrels for 40 long lateral horizontal wells with an average of 550 MBO. The expected recovery factor would be about 7.9% over these 40 wells. And that would be a reasonable recovery factor.
And finally, turning your attention to Exhibit Q, please explain what this reflects.
So Exhibit Q is just a comparison of the economics between a 330-foot setback and the 100-foot setback. And what it's indicating is that the economics would favor the reduced setbacks of 100 feet.
All right, would you please address for the board and the division why these drilling unit boundary wells are necessary?
Yeah, so if you refer to Exhibit N, you'll see that there is a gap of about 560 feet with the existing setbacks. And so this additional DSU between the DSUs, as I like to think of it, would allow us to drill additional 5 wells, up to 5 stacked wells, targeting each one of the individual zones that Mr. Jennings identified. Those are necessary to recover the additional resources left in place by the existing 660 or 560 setbacks.
All right, is it your expert opinion then that the reduction of the heel toe drilling unit boundary setback is required to recover additional resource that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the requested reduced setback should not result in adverse draining or waste and be protective of correlative rights?
Yes.
And finally, is it your expert opinion that up to 5 drilling unit boundary wells with a 330-foot tolerance on each side of the boundary line are required to recover additional resource which would otherwise be left in the ground?
Yes.
Madam Chair, that concludes my examination. Mr. Wall.
Thank you. Division.
Regina Echo of the division has some questions.
This is in regards to the PVT data. What makes
Ms. Echo, your mic is off.
sorry. What makes this, the question is in regards to the PVT data for the NOL 13-10-4-2-15-7H. What makes this well a representative of the data that was provided?
The simple answer is that it's the closest well that we have PVT data collected on.
No additional questions from the division. Thank you.
Board, do you have questions of this? Seeing no questions, please proceed.
Thank you, Madam Chair. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A through Q inclusive.
So admitted.
No objection?
Oh, I'm sorry.
No objection.
Board? So admitted.
Thank you, Madam Chair. With that, we believe that we have satisfied all the statutory and regulatory requirements for granting the request. This will allow for a greater recovery of resource without waste and with protection of correlative rights. I'd like to thank the board for their time and attention, and particularly the IT staff for allowing the witnesses to participate virtually in this matter. Thank you.
Any final closing comments?
The division has reviewed the request as well as the submitted exhibits, and upon hearing the evidence today has no objection to granting the request.
Board, Mr. Moon.
I would move that we accept or that we approve this request.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Please note it's passed unanimously. Mr. McDonald, would you please prepare the order?
I'd be happy to. Thank you, Madam Chair.
Thank you. Mr. McDonald, would you just let me know when you're ready?
We're ready if the division is.
Oh, okay. Division, are you ready? Okay. We're going to move on to item number 6. Docket number 2024-044, cause number 475-09. In the matter of the request for agency action of Anschutz Exploration Corporation for an order suspending Utah Admin Code 649-3-2, 649-3-10, and 649-3-11 sub 1 sub 2 as to the Canvas Deep, Glacier Deep, and Tarn Deep federal units comprised of portions of townships 10 through 12 south, ranges 22 through 24 east, Salt Lake Meridian, Uinta County, Utah. Appearance of counsel.
Thank you, Madam Chair. Fred McDonald of counsel with Lear & Lear on behalf of petitioner Anschutz Exploration Corporation.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Please proceed.
Thank you, Madam Chair. With me today to testify are Mr. Brett Willis, Supervisor of Colorado and Utah Lands, here in person. And appearing virtually pursuant to the board's August 21st order are Mr. Craig Cormany, the Senior Staff Geologist. Mr. Cormany, would you wave so they can see who you are? Thank you. At this time, I would ask that these witnesses be sworn in.
Can the witnesses please raise your right hand? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do. Yes.
Thank you. The resumes of both witnesses were collectively submitted as Exhibit A in this cause. If separately and individually asked about the contents of their respective resumes, the witnesses would confirm the same. Mr. Willis will be a fact witness only. As this is Mr. Cormany's first time appearing before the board, I will qualify him as an expert in geology at the commencement of his testimony. And again, Madam Chair, I will move for admission of our exhibits as a whole at the end of our presentation in chief.
Thank you.
Members of the board, as outlined in the request for agency action, Anschutz is the designated operator of 3 federal exploratory units in Uinta County: the Canvas Deep Unit, the Glacier Deep Unit, and the Tarn Deep Unit. The 2 former are limited to depths below 100 feet below the base of the Mesa Verde Formation, while the latter is limited to the Mancos Formation and deeper. The Canvas and Glacier units were approved earlier this year, while the Tarn unit was approved in 2022 and partially contracted this year. Each unit in large part is comprised of federal oil and gas, with some state, school institutional trust lands, oil and gas, and a few fee owners as well. As a consequence, these units are administered by the Bureau of Land Management. There are currently no board orders relating to these units. As such, the general operational rules, including the General Well Siting Rule R649 3-2, have and still remain applicable to the entire unit area. As the testimony today will reflect, Anschutz to date has drilled 1 horizontal well each within the Canvas and Tarn units. However, they required exception location approvals from the division because they crossed lease section lines pursuant to that General Well Siting Rule. As the board is aware, Rule R649 2-3 allows suspension of the general operational rules as to lands within approved federal units. The board has granted this relief on several occasions, the most recent of which I'm aware was in 2020 with respect to the KJ2 unit in cause number 475-02. A true and correct copy of R649-2-3 was submitted as Exhibit O in this cause. Units allow for the most efficient and economic manner of exploration and development because the unit operator can develop on the basis of reservoir characteristics and not based on some arbitrary spacing or well siting pattern. R649 2-3 expressly recognizes this and allows for suspension of the existing board rules as to federal units so long as the conservation of oil and gas and the prevention of waste are accomplished thereby. The evidence presented today will show that these 3 unit agreements and operations conducted thereunder are intended to and accomplish the conservation of oil and gas and the prevention of waste. There are important caveats to Anschutz's request. To protect correlative rights, Anschutz agrees that no well may be drilled closer than 660 feet to a unit boundary or to an uncommitted track within the units without an exception location approval by the division or the board. Also, the requirement to provide a directional survey as to any directionally drilled well remains in place. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-5, subparagraph 3B, and Utah Administrative Code R649 2-3. A copy of the request was sent via regular mail to all owners within the unit areas, to SITLA, since the state lands are committed to the unit, and to the Bureau of Land Management, both to the state office and the Vernal Field office, as federal leases are included, and the BLM is the supervising agency over the units. These were sent to their last addresses disclosed by the relevant agency and Uintah County Realty records, as well as Anschutz internal records. Notice of the request in the hearing was also duly published in the Deseret News on August 2nd, 2024, the Salt Lake Tribune on August 4th, 2024, and in both the Uintah Basin Standard and Vernal Express on August 7th, 2024. On August 12th, 2024, the division filed a response to the request stating its non-opposition to its granting, presuming that Anschutz meets its burden of proof at today's hearing, which we will do. No objections or other responses have been filed, and no other party has made an appearance in this matter today. With that, I'll commence my examination of Mr. Willis. Mr. Willis, would you please state your name and business address for the record?
Yes, my name is Brett Willis. I am supervisor of Colorado and Utah land, and our business address is 555 17th Street, Denver, Colorado 80202.
And you have the responsibility over the land of these 3 units, is that correct?
Yes, sir, I do.
All right, since this is Anschutz's first time in front of this board in several years, and particularly since these are all new board members, can you provide a little background about the company, just so that they're familiar with it, and then also its corporate and bonding status?
Yes, I'd be happy to. Anschutz was founded over 60 years ago. We are a Denver-based private independent oil and gas company with assets located in Utah, Wyoming, and Colorado. Anschutz has participated in significant discoveries and development of oil and gas resources worldwide, including in the Uintah Basin. Over the past 10 years, Anschutz has invested significant resources to expand its presence in the Uintah Basin and is actively evaluating and appraising its Uintah Basin assets. Anschutz is a Delaware corporation in good standing, duly authorized to conduct business in the state of Utah. Anschutz is duly bonded with all appropriate state and Utah and federal agencies relevant to this cause.
I'm going to show you now what have been marked as Exhibits B through H. Some of these are documents that are also in our file. Do you recognize these documents?
Yes, sir, I do.
And were they prepared by you? Well, let's go back. Exhibits B, C, E, and G, were they prepared by you or Anschutz personnel with your review and input?
Yes, sir.
And with respect to Exhibits D, F, and H, are they official business records of Anschutz?
Yes, sir.
Okay, turning your attention first now to Exhibit B, would you please explain to the board what this shows?
Sure. So Exhibit B is a regional locator plat. The purpose of this exhibit is to show you where our 3 respective units are located. So all 3 units are contiguous. They're a handful of miles southwest of Bonanza. The Glacier unit is the most north unit. It's identified by the blue polygon. Southwest of that is our Canvas unit. It is identified by the orange polygon. And southeast of Canvas is our Tarn unit, identified by the green polygon.
Now turning your attention to Exhibit C, please explain what this reflects.
So this is an exhibit of our Canvas unit. The Canvas unit boundary is identified by the blue polygon. Also illustrated is the existing producing well, which is the Bierstadt fed well. The Canvas unit was approved by the BLM effective May 20, 2024. The oil and gas underlying the Canvas unit area are primarily owned by the United States. They own approximately 23,782 acres, or 92% of the unit. The remaining balance is owned by the state of Utah. They own approximately 1,920 acres, or 7.4%, and then the remaining balance is by private owners in fee who own 121 acres, or 0.47% of the units. Unit Tract 26, which is a federal tract, is uncommitted, and Unit Tracts 44 and 45, our fee, are also uncommitted. These 3 tracts cumulatively amount to 170 acres, or only 0.65% of the unit. Like I mentioned earlier, the Bierstadt well, this well is specifically known as the Bierstadt Fed 1123-16-28-14 MCH well within the unit area. It is not to be considered for inclusion within a unit participating area until the unit obligation wells are drilled and produce in paying quantities and a unit participating area is established.
Right now I'm going to turn your attention to Exhibit D, which is a document. There's not a PowerPoint for it. Could you please explain what this document is?
Yes, this is the approval letter of the Canvas Deep Unit Agreement dated May 21, 2024 from the United States Department of the Interior.
It's also the unit agreement, is that correct?
Exactly. Also included as part and parcel of the letter is the unit agreement itself.
Okay, on the PowerPoint are some relevant portions of Exhibit D, starting with the third from last paragraph of the transmittal letter, which is the top quote that's shown here. Would you read that into the record, please?
Yes. In view of the foregoing commitment status, effective control of operations within the unit area is assured. We are of the opinion the agreement is necessary and advisable in the public interest and for the purpose of more properly conserving natural resources.
And again, that's the transmittal letter from the BLM approving the unit.
Yes, sir.
All right. Now, pointing out to the fourth recital on page 1 of the unit agreement, which is in the middle there, would you please read that into the record?
Yes. Whereas it is the purpose of the parties hereto to conserve natural resources, prevent waste, and secure other benefits obtainable through development and operation of the area subject to this agreement under the terms, conditions, and limitations herein set forth.
All right, and finally, I want to point out section 16, which appears on page 8 of the unit agreement. Please read that into the record.
Section 16, conservation. Operations hereunder and production of unitized substances shall be conducted to provide for the most economical and efficient recovery of said substances without waste as defined by or pursuant to state or federal law or regulation.
Thank you. Now turning your attention to Exhibit E, please explain what this shows.
Exhibit E illustrates the exterior boundary of our glacier unit. The glacier unit was initially approved by the BLM effective May 16, 2024, with this first expansion approved effective June 1, 2024. The oil and gas underlying the glacier unit area are primarily owned by the United States, who own 25,511 acres, or 93.4% of the unit. The remaining acreage is owned by Sitla, who own 1,344 acres, or 4.9% of the unit, and by private owners in fee, who own the balance of 457 acres, or 1.68% of the unit. Unit tracts 23 and 24 are state tracts and remain uncommitted to the unit. And unit tracts 26 and 28 are fee tracts, are also uncommitted. In totality, those 4 tracts are comprised of 1,394 acres, or 5.1% of the unit.
Okay, this does not reflect any wells that have been drilled in that unit yet, is that correct?
Yes, sir.
All right, turning your attention to Exhibit F, this appears to be the transmittal letter and unit agreement for the glacier unit, is that correct?
Yes.
All right, and rather than going through it again, do both the transmittal letter and the unit agreement contain the same provisions that we talked about on Exhibit D?
Yes, they do.
Okay. Now turning your attention to Exhibit G, would you please explain what this shows?
Exhibit G is a plat of our Tarn unit. It illustrates the exterior boundary of the Tarn unit. Also illustrates the existing producing well, which is the Torrey's Fed well. The Tarn unit was approved by the BLM effective December 8, 2022, and has been partially contracted effective April 1, 2024. The oil and gas underlying the contracted Tarn unit area are primarily owned by the United States, who own 19,030 acres, or 82.1% of the unit, with the remainder owned by Sitla, who own 2,945 acres, or 12.7% of the unit. The balance owned by private owners in fee, who own 1,200 acres, or 5.1% of the unit. Unit Tract 7, which is a federal tract, remains uncommitted to the unit, and Unit Tracts 28 and 32 are fee tracts, are also uncommitted to the unit. These 3 tracts total 125 acres, or 0.54% of the unit. Anschutz drilled and produced the Torrey's Fed 1124-32-29-4X MCH well. It was drilled as the unit obligation well and is awaiting unit paying quantities determination by the BLM and consequently participating area establishment.
Now turning your attention to Exhibit H, again, this appears to be the transmittal letter and the unit agreement for the Tarn unit, is that correct?
Yes, it is.
And do these also contain the same provisions that we talked about with respect to Exhibit D?
Yes, they do.
Thank you. Would you confirm for the record that Anschutz has and will continue to operate the unit under these governing conservation principles?
Yes, we will.
All right, will you also confirm that Anschutz will maintain a 660-foot set-off from the unit boundaries and uncommitted tracks, or if it's necessary, will seek an exception location from the division or board?
Yes, we will.
All right, and Mr. Cormany will address the issue about the 660-foot reason for that. Finally, will you confirm that Anschutz will provide directional surveys under R649-3-11 subparagraph 3?
Yes, we will.
All right, now I'm going to turn your attention to a certificate of service, which again was a pleading prepared by my office in this cause. There's several names and addresses shown on there. Do you recognize those names and addresses?
Yes, I do.
And who are they, and how are they determined for purposes of this cause?
They are all production owners within the respective 3 units. The names and addresses were obtained from our land records, internal land records, as well as BLM records, state records, and Uinta County Public Recorder's Office.
And your internal land records include title opinions?
They
et
do.
cetera?
Yes,
Okay,
sir.
thank you. Madam Chair, that concludes my examination of Mr. Willis.
Thank you. Division?
Thank you. Just a couple questions, Mr. Wells. Just humor me for a minute. So we have these 3 units. They're all very close together. Why are they all separate units? Why not like one large unit? Could you explain that to me in simple terms?
This feels like a softball because I think in an ideal world, we would prefer to have one big unit. So they have been created over the past couple of years. And as you know, it's quite difficult to sort of come up with the actual shape of the units. They end up becoming odd shapes for a variety of reasons. But first, they have to be technically sound. So the geologists have to say these lands are productive of producing commercial hydrocarbons. We also have to respect the fact that we may not own all the leases. We have to respect unleased lands. And we have to make sure that we're including leases that we could actually drill and would make sense for us to drill, meaning high working interest leases. Ideally, though, it would be nice to have one big unit.
And so with that in mind, I noticed that you said 1 or 2 of the units did have uncommitted federal tracts. How does that happen? How does an uncommitted federal tract happen in a federal unit?
Sure. It's uncommitted because we don't actually own the lease.
Okay.
A third party owns the lease, and to date, we've been unsuccessful in obtaining their joinder or commitment to the unit. Ideally, we would have them commit to the unit because it does cause some challenges to us. For instance, the setbacks, we have to honor that, and so that can be disruptive to a logical development pattern in our units.
Yeah. Okay, thank you. I did have one point. It was in the request. This was pointed to me in the division by the division when we were talking about the first unit, the Carn unit. Oh, sorry, the Canvas Deep. That has a depth limitation, and it's tied to the Torrey State well. The division pointed out to me that that well that is in the request doesn't exist. So I don't know if that's something we may want to double check. Where did that depth limitation come from when you were submitting this request?
I apologize. I don't have an answer for you.
It would be in the unit agreement, and it's possible that it says the Torrey State 1124-32-4 well. That's the definition in the unit agreement.
Torrey State. Can you say that one more time, please?
1124-32-4 well, located in the southwest quarter of section 32, 11 south, 24 east.
Okay.
It's straight from the unit agreement.
Okay. We'll have to look into that because, yeah, it was pointed out to me that they could not find that well in our system. So that's something we can talk about later. But,
Okay.
yeah. On that, no further questions from the division. Thank you.
Madam Chair, if I could just, I would like to ask Mr. Willis just a clarifying too. Also on the limitation of the units, isn't that a BLM requirement as far as you can only get a unit so big without multiple well development?
That is correct. There is a general understanding that the BLM does limit the size of units, BLM exploratory units.
So approximately 25,000 acres per unit, is that correct?
That has, yes.
All right, thank you. That's all, Madam Chair.
Without going back and looking at each one of them, are all of these limited from the Mancos Formation and deeper for unitization?
Yes, ma'am, they are.
So the shallower depths are not unitized?
That is correct.
Okay.
Mancos and below, in all
Okay.
three.
And just roughly, where are the uncommitted tracks? Are they out in the middle, or are they along an edge, or where are they?
So in the Glacier unit, there are 2 BLM uncommitted. I'll just speak to the federal leases, unless you'd like to know about the B leases. They're much smaller. The BLM leases are in the southwest portion of the Glacier unit.
Okay.
In the Canvas unit, I actually do not recall where the uncommitted tracks are off the top of my head. I apologize. I am familiar with the location of the Glacier uncommitted tracks, just not the Canvas or Tarn.
Board, do you have any other questions? Okay.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Cormany. If we could have him, IT people, thank you. Mr. Cormany, would you please state your name and business address for the record?
Yeah, my name is Craig Cormany, and my business address is 555 17th Street, Suite 2400, Denver, Colorado, 80202.
Okay, are we having a feed issue there? Is it a delay?
Yeah, stand by.
Major delay.
Didn't know we were ventriloquists. If you could stand by, Craig.
Yeah, give us 1 second. We're gonna reroute this a little bit and see if we can't fix this. Give us 1 second. Mr. Cormany, can I just have you say something real quick, see if we can fix that sync issue?
Yes, hello, I'm a geologist.
Okay. Yeah, stand by. Still have the issue. Hold on. Will you give us a sound check one more time, Mr. Cormany?
Yes, Craig Cormany.
Thank you. Okay, I think we've got that resolved.
Yes, thank you. All right, again, Mr. Cormany, would you please state your name and business address for the record?
Yes, my name is Craig Cormany, and my business address is 555 17th Street, Suite 2400, Denver, Colorado, 80202.
All right, what's your current position with Anschutz, and how does it relate to these 3 units?
I'm a senior staff geologist, and I am in charge of looking after these assets from a geology perspective for Anschutz exploration.
Okay, would you, since this is your first time appearing in front of the board, would you briefly outline your education, work experience, particularly experience in the Rockies and basins analogous to the Uinta Basin, such as the Piceance? Any certifications or license or publications, that stuff, so that we can qualify you?
Yeah, I've got 2 geology degrees, and my master's degree has an emphasis in sedimentology from Ohio University back in 2001. So I've got over 20 years experience, largely in exploration, and most of it in the western United States in a variety of basins, including the Uinta, the Piceance, the DJ, and the Powder, and in addition to the Mid-Continent.
All right, with that, in addition to his resume, unless the division has any objections, I'd ask that the board recognize Mr. Cormany as an expert in geology for purposes of this cause.
Division, do you have any objections?
No objections. Just can I just ask a couple additional questions?
Sure.
That's okay. Mr. Cormany, could you just explain to the board and the division kind of what your day-to-day duties are within Anschutz?
Mostly it involves going to a lot of meetings. No, I correlate logs. I map isopachs of formations, and I try to discertain depositional environments to kind of get an idea of where our reservoir rocks and where our hydrocarbons might exist in the subsurface. And then additionally, I help site wells and help geosteer wells into those formations. So I do a lot of math and a lot of map making day to day.
Okay, and just in general, what would you say, how many years of experience do you have working in this specific area?
In this specific area, I would say in this very specific area, I started with Anschutz in April of 2024. I have looked at this region briefly with EOG Resources back in 2009, 2010.
Okay, and so most of your experience would be in what region would you say?
Oh, I started off my career in the Appalachian Basin drilling shale wells. And then I moved to the mid-continent, working in Oklahoma City in the Texas Panhandle and the Oklahoma Panhandle, where I had a couple horizontal discoveries. And then from there in 2010, I moved to Denver and I helped with an exploration team working in the Powder River Basin in the Parkman play. And then I moved on to take a look at basically a little bit of this area and work in the Paradox Basin and some of the Piceance. And then I moved on to Samson Energy, another privately held oil and gas company. And our assets were primarily, we looked at stuff all over the continental United States, and we settled on an asset in the northern DJ Basin, where we ended up drilling over 100 wells in the Codell and Niobrara formations, which we're talking about the Niobrara Mancos here, which is a very similar formation, although this is a little thicker. But we helped drill over 100 wells in the northern DJ Basin around Silo Field. And then after that, I have moved on to work with Anschutz Exploration.
All right, thank you. No further questions. No objections from the division.
Thank you, Madam Chair. Mr. Cormany, I'm going to show you what have been marked as Exhibits I through N. Do you recognize these exhibits?
I do.
And were they prepared by you or Anschutz personnel with your review and input?
Yes, they were.
Okay, turning your attention to Exhibit I, would you please explain to the board what this shows and its significance to today's hearing?
This is a structure map based on the top of the Mancos N formation as we map it. And you can see on the map, we've got the units displayed there with the brown outlines. All of the penetrations that went into making this map are much broader than the map, but the ones particular to this area are all of the blue dots. So this is a structure map, basically structure below subsea, so that formations are dipping off to the north and west, getting deeper off to the north and west.
All right, and turning your attention now to Exhibit J, please explain what this shows and its significance to today's hearing.
Okay, this is an isochore map, basically an isopach map of the thickness of the Mancos N, which I will show you on a type log on the next slide. But you can see that the formation is consistent throughout the entire area we are trying to unitize here. And it's roughly on average 1,800 feet thick across this entire region of the Uinta Basin. And again, those penetrations that the map is based on are the blue dots.
Now turning your attention to Exhibit K, please explain what this shows.
Okay, this is a type log from the Bierstadt pilot hole. The Bierstadt is a horizontal well that we drilled in the canvas unit, and this is the pilot hole that we drilled to basically ascertain which horizontal target we wanted to drill. And that previous isopach map was basically this blue bar on the left-hand side of that gamma ray log. And what you can see on the log is the gamma ray, the resistivity, and then we have a porosity curve and basically a mud gas show. And the intervals of interest to us are those red stars. We believe those are all reservoir units. Roughly it's 1,800 feet thick with four 4 dominant calcareous organic rich mudstone units. The TVDs are roughly 7,200 to 9,000 feet TVD. That's true vertical depth, not subsea, as previous map. It's got decent total porosity, averaging 6%. Permeability is on the range of 3 nanodarcies, and the TOC averages about 1.4% from the cuttings and the core. A lot of this data is from our proprietary core that we have collected and publicly available samples. Clay ranges from 10 to 46% with a median range of 31%, and the carbonate averages about 24%. And again, all that data is from cuttings and core.
Now moving on to Exhibit L, would you please explain what this shows?
Yes, Exhibit L is the locator map for a cross-section A to A prime. A is basically in the center of the map, in the south center of the map, at the Torrey's pilot hole. And then the cross-section continues to the north, and then it swings around off to the east and to the south.
And then Exhibit M, this is the cross-section that you referenced in that prior exhibit. Please explain its significance to this cause.
Yes, sir. This is to diagrammatically show that the Mancos N is consistent and very uniform across our geographic area.
Now turning to Exhibit N, please explain what this shows.
Exhibit N is a oil and gas calculation based on the average porosity and the average height and the average SW that we were experiencing in the Bierstadt pilot hole data that we take off that other log. Basically, it's trying to establish that there's a 320 acre or a 4-well spacing unit within our units. I can run through the math real quick, but the upshot of the thing is our reservoir engineers have calculated that our Bierstadt well has an EUR of 8 BCF. Now using 320 acres, which is a 10,000 foot lateral at 660 spacing, and an average height of 514 feet of pay with cutoffs, that's 3% cutoff and an SW of less than 60%, I calculate that there is original oil and gas in place of 45 BCF within that 320 acre spacing. So that gives us a recovery factor of only 18%. So I do not believe that we will be accessing any oil and gas outside of these 320 acres.
So I'll put it in other words, that if there's a 660-foot buffer between uncommitted tracts or unit boundaries, you don't believe there would be any drainage of the adjacent lands. Is that correct?
That's correct, sir.
All right, thank you. Are there any other factors that justify the suspension with the development of these units? Did you hear me, Mr. Cormany?
Is that a question for me?
Yes. I was going to ask you, what are the other factors in the development out here that justify the suspension of those rules?
I guess I would like to confer with you on this.
Okay, maybe let me ask Mr. Willis that question. Maybe that's better for him.
Yeah.
All right, I'll follow up with him later. Okay, with that, is it your expert opinion then that the continuity of the Mancos through the Eunice areas make it attractive for horizontal well development?
Yes, sir.
Again, recognizing that you're a geologist, but you work with the engineers and all of that, is it your opinion also that the 660-foot setbacks from unit boundary and uncommitted tracts will be protective of Corella rights of the adjacent owners and not commit waste?
That is correct.
Right. Finally, is it your expert opinion that the suspension of the well rules will allow Anschutz flexibility to optimize placement of wells for resource recovery while minimizing surface impact?
Yes, that's correct.
All right. Madam Chair, that concludes my examination of Mr. Cormany, but I would like to ask Mr. Willis one other question follow up on.
Okay, let's finish with him first. Division?
Division has no questions for this witness.
Seeing no questions from us, please ask your question.
Thank you, Madam Chair. Mr. Willis, are there other factors that are involved in this area with these units that would justify suspension of the well siting rules?
Sure, yeah, there are significant topo challenges, meaning the surface lands do provide challenges to locate our pad locations.
All right. And what do you normally utilize? Do you use multiple well pads to minimize surface impact as well?
Yes, we do.
All right, thank you. Madam Chair, that's it.
Division, do you have questions?
All right. No questions. We can give our closing statement if that's what you'd want at this point too.
Okay, let me check with the board first. We're good. Please continue.
As to this request, yeah, the division reviewed this request. As Mr. McDonald alluded to, this is similar to other federal units, the rule suspension. The division has no issue with suspending the rules as requested. The only caveat the division would point out, and I assume this is meant already, we just wanted to make it clear that the suspension of these rules will be limited to just the unit area within these units, and as they contract or whatever happens to them, that the order will follow just those unit areas, and then it's also limited as to the depths, which I believe was the main coast or deeper.
Okay.
Thank you.
Good deal. Any further questions from the board?
Madam Chair, if I could move for admission of the exhibits.
Yeah, that will be fine.
Move for admission of exhibits A through O inclusive.
Division, do you have any concerns?
No objections, no.
Okay. So admitted.
Thank you, Madam Chair. With that, we believe that the requirements for application of R649 2-3 have been satisfied. These units clearly are in the interest of conservation. The protective caveats that have been added will protect correlative rights and also prevent waste. And we believe that we've met everything, and we would ask that the board grant the request as submitted.
Board, do we need to confer? Are we ready to make a decision? Okay, can I have a motion?
I move that we approve the request for agency action and also with the parameters and limitations that the division has asked for.
Second that.
It's been moved and seconded. All in favor?
Aye.
Aye.
Any opposed? Please note it was passed unanimously. Would you please prepare the order, Mr.
I will,
McDonald?
Madam Chair. Thank you.
Thank
you, board members, for your attention.
Thank you.
Thank you very much.
We have one further issue from the Dogum folks. Is someone prepared to? Okay.
Just a moment, technical difficulties. Okay. Yeah, we're ready when you are. Yeah. Oh, yeah. No problem. Thank you. Assistant Attorney General Andrew Haynes on the behalf of the Division of Oil, Gas, and Mining. I'm joined today with Orlin Wallace, who's the Division Permitting Manager, and Adam Miller, who is Environmental Science 3. He also works as the Pollution Control Exemption Tax Reviewer. I believe that's correct. Madam Chair, members of the board, we're here today to try to fulfill our statutory duty to pass a rule that helps to cover the division's portion of the Pollution Control Act. So we have a presentation here. I know it's been a long day for people. If you feel like you know about this and you want to move on, just let me know. But we're here to basically answer questions about the rule that we've put together for the Pollution Control Act, so the division can run this program. And we will not take a long time, I promise you. So we're here because House Bill 373 was passed in the 2024 general session, which made amendments to Utah Code 19, Chapter 12, which contains the Pollution Control Act. In general, the Pollution Control Act allows a sales and use tax exemption on the purchase or lease of property that is used for a primary purpose of pollution control. However, before a person may claim the sales tax exemption, they must obtain a certificate. Certification allows a person to obtain a refund on taxes paid for qualifying property from the State Tax Commission. House Bill 373 made changes to the Pollution Control Act, wherein it now requires certification for property within the jurisdiction of the Board of Oil and Gas and Mining to be performed by the division director. The certification authority was previously held only by the Division of Water Quality and Air Quality. Because the board has authority to regulate all operations for and related to the production of oil and gas, then any request for certification within those realms will now come to the division instead of those agencies. HB 373 also included authority for the board to make rules to establish procedures for evaluating and processing certification applications. It also amended Utah Code 40-6-5, which is the jurisdiction of the board to allow for rulemaking related to the Pollution Control Act certification. And it changed 40-6-16 to include implementing the Pollution Control Act as part of the division's duties. So based on House Bill 373, the division commenced drafting a proposed rule. The proposed rule is based on the Division of Water Quality and the Division of Air Quality's existing rules. In full candidacy, we're very similar. There's not very many changes, if any, to these rules. The proposed rule was then part of stakeholder engagement, which the division received comments from the Utah Petroleum Association. It's noted that after our communications, the UPA also filed a letter of support for the proposed rule. After stakeholder engagement and during the June briefing session before the board, the division requested the board to approve the commencement of formal rulemaking. The request was approved by the board. The division subsequently filed the rule with the Office of Administrative Rules, and it was published as required by the Utah Administrative Rulemaking Act in the Utah State Bulletin. No additional comments have been received by the division during the public comment period. With that in mind, that's the background for this rule. The rule was attached as Exhibit 1 to our notice of agency action. I don't know if you've had time to review it or where you want to go with this, but I have now Orlin and Adam. They're going to just say a little bit about the rule. So if you have questions on specific things, they will know way more about it than I do.
Chairman of the board, Orlin Wallace. Yeah, we had the opportunity, Adam and I, to basically what we had done is went to the air quality site. And we had another gentleman in the division, Paul, help us put this all together, but we basically copied the rule, not copied, but almost verbatim for air quality on this because it was already pre-written in theirs. And so we're going to be doing the same thing. So the rule states that we go out, or we actually make a determination whether something that the oil and gas companies bring before us is, in fact, something to control pollution. So, I mean, we have different. There's two different pollution controls that we deal with. One is we got the freestanding, and also we've got the so freestanding pollution control means things like the well site, whether it's combustor, something on the combustor, and then also we have it pertains more to the real estate side, and what it is it let me pull it up here, but it's actually called the pollution control facility. And so what's been going on, we got with Division of Water Quality and talked to them about the whole rule. And so this rule is instituted so that they could get these tax breaks. And a lot of water quality, they were dealing with injection wells. So an injection well is something on the real estate side, which is actually a facility. When you think of facility, we think of things tied to real property. So basically what we're going to do, this rule constitutes us to take and make a determination through the application process whether something is actually a pollution control, whether it's a facility or whether it's a freestanding pollution control device. So it's quite a arduous process. We made up a little flow chart to help us out in this process, and as presented here, this is the application process that we're going to have to go through. In the rules, it states the division director is going to be the one that approves this on behalf of the board. And so as we walk through the application process, there's some various things that's going to happen that's different than we've ever dealt with before. Is normally I go through an application, we send it to people within the division, and they review it and they look at their portion of it. This one we're going to actually review here. That'll be Adam. He'll get that stuff and he'll review it, and then actually during that time we'll have an application that is sent to Utah Tax Commission for them to review at the same time. And then they have 30 days to actually get that back to us so we can get this permit. There's a set number of days that we've got to have these certificates reviewed and approved by. And so 120 days. So 120 days is the process that we got to be able to issue these. And so the big thing that and this is something that's new to us. A lot of our dealings is downhole expertise. Now we're dealing with air pollution and water pollution control devices. So what's going to happen with these rules is we're going to take it and it's a case by case basis whether they get approved or not, and we're going to look at the devices that they're submitting. And actually, I brought in some things that let me read to you. But so here's what it states in the Utah Code section 1912-102, and we refer to those codes for some of this. Pollution control facility means real property in the state, regardless of whether a purchaser purchases the real property voluntarily or to comply with a requirement of a government entity. And basically, and it says, if the primary purpose of the real property is prevention, control, or reduction of air pollution or water pollution by, and then it goes on, the disposal or elimination or design to eliminate waste and use of treatment works for the industrial waste, or the disposal, elimination, reduction of, or redesignation to eliminate or to reduce air pollutants or air contaminants, and the use of one or more air cleaning devices. So there's a few things out there. I mean, it gives us some it really doesn't give us a whole lot to go off of as we're going through this. So Adam and I, we've reached out to DWQ so far. Our next steps is going to be to reach out to DAQ and visit with them on some of the things that they were approving. But the tax commission overall, they have it set up. And I called the tax commission the other day and talked to them about some stuff, but they finally got me. Adam looked up the gentleman's name, and then they gave me the same information, but we got to call him and go over some things that they approved and didn't approve before. So it's going to be a case-by-case basis of what we review, whether it's water quality, injection wells, that's going to be like on the water quality side, trunk lines, gathering lines, things like that is some things on that's going to be approved. And then any pollution control device at the well site, so what they did is they deemed that, okay, you guys have oil and gas experience. You go out there, you look at these well sites every day. So this is why the rule was pushed to us through the legislative process. And so it's a new thing to us. We're excited. Adam and I, we've been working hard. We're actually, just so you know, we've actually got some applications in already. We actually moved this whole process. Instead of going with our e-permit process that we have now, we are now getting ready to go live on Salesforce so that we can approve applications through Salesforce. And this is going to be the opportunity to segue us in the future to be able to also do the APDs through the Salesforce process. So it's given us a learning curve there in Salesforce to see what we need to do in the future. So this is, right now we've got operators that have entered these already in Salesforce. And so Adam and I have been working on that, and Adam's been paying specific attention to what's coming in, and basically we're kind of standing up two things at once. So we've got Salesforce we're standing up, and then we got the Pollution Control Act we're standing together. So it takes a lot of our time, but this is a new learning curve for us. So we're excited.
Thank you, Mr. Wallace. Could we move on, Mr. Haynes?
Sure. So with that in mind, we're now before the board to request that the board adopt our 649-12 as currently proposed and set an effective date of August 28, 2024, so we can continue to implement this rule.
Board, does that require a motion? I think we should do. Could I get someone to make a motion that we accept?
I move that we approve the request to move forward with this rulemaking process.
Second?
I'll second.
Did you get that? All in favor? Please.
Aye.
Any opposed? Please show it passed unanimously. Please proceed, Mr.
Thank you.
Thank you. And I don't see Mr. Mayo in the room. Oh, he's hiding. And Mr. Cahoon is here. Please let the record show we are returning to docket item number 2024-007, cause number 199-05, that we continued from before lunch. Mr. Mayo, please begin. Have we resolved the issue?
despite some good efforts, I would say we didn't resolve the issue.
We did try hard, didn't we?
We talked for a while. The truth is, this is probably without. It's hard to know what amount you're willing to settle for until you know what amount you're owed. So we're still kind of in that same stuck spot. As far as proceeding, I've got some ideas on how the board can wrap this hearing up and kind of prepare for what comes next. But unfortunately, we weren't able to resolve anything.
Okay, would you proceed with your side of the argument, Mr. Mayo? And then we will let you counter.
Sure, I'm happy to. Thank you. Again, appreciate everyone taking the time. We know these contested matters can be a headache. The truth is, the board is here to make the determination as it's decided, the only determination. ARB has agreed Prochetti's entitled to a 25% working interest in these wells. They've agreed there's production. They've agreed they haven't paid him, and they've agreed they haven't suspended it. So all those determinations are made for us at this point. The only determination the board has to make is whether not having a signed JOA, a newly signed JOA, is a reasonable justification for not paying someone. I would argue, given the pooling statutes, that would be not only a bad decision, but an incredibly dangerous decision for this board to make. I can imagine an operator in the basin just saying, I've moved your proceeds into our operating account. You're entitled to something, but until you sign a JOA, I don't have to do anything. And that's not what the board or the statutes intended. The truth of the matter is, there was no reasonable justification. And that's, I think, been established now. Upon making that determination, there's a couple other determinations the board has to make. And without suspending in an escrow account, the board's hands are tied. Whatever proceeds Dr. Prochetti is due are entitled, as a matter of law, to 1.5% interests per month. And so that determination flows naturally from that. In addition, we believe that it's appropriate for the board to assess a penalty amount on the amount that's due and owing. Now, we don't know the numbers here today. The board has made a determination that given the way information was presented to the board, it's not the right day to address that. And I understand. However, we're talking about a set number. We may not know what it is, but it is a set number. It is proceeds of production attributable to his interest. And on that basis, I think the board has every ability it has to say he is entitled to a number, his proceeds. And we believe that there's no reasonable justification. So we're imposing 1.5% penalty per month interest, and we're imposing a 25% penalty on top of that for their failure and their lack of explanation. We will determine at a later hearing what the actual number is to put in there. But I don't think this process is designed, to be honest, to go on for 9 months before you really get the heart of the issue, the information you're looking for. I think this is meant to be a shortcut, an easy way for this board to oversee the companies that it does. And I think that's how it should be interpreted, right? Dr. Prochetti's not an oil and gas company. He's an individual who invested in oil and gas and has done everything he can to try and get that investment to materialize, to return. The problem is he's just stuck getting that information. And we heard today from ARB, and I believe them, the president said we're able to provide all that information and documents today. And I believe them, and I think this board should say, great, let's do that. Give us all the documents. We'll have another hearing in September. I know the September docket is busy, but I do believe this board could and should set this matter as quickly as it can for that accounting process. Dr. Prochetti is entitled to his relief before this board as well. And timely relief is part of that relief. He's waited nearly 5 years now to get any payments. They've acknowledged they owe him over roughly $500,000 according to their calculations. There's no justification for that. And so kicking the determination as to penalties or as to interests to another month and another month doesn't serve any purpose, in my opinion. The board has all the information it needs. There is no reasonable justification for the delay. And I believe that we can come up with an accounting hearing where the board is presented with two different sets of numbers to the extent they disagree, right? Once we get the documents from ARB, we may say, These make perfect sense. Your accounting is correct. That's the right number. That's what you owe us. It's entirely possible. We just don't know that. But at the hearing, the board would be presented with simply clean numbers. Here's our set of numbers. Here's their set of numbers. Here's the issues that we're disputing. Determine which one is correct. And we believe that's the best approach. Dr. Percetti has done what he's supposed to do. He's come in and he's met his burden. He's here asking for your help. You've got all the information you need to make that determination, and we would ask you to make that determination. And with that, unless there are further questions, I'll turn the time over.
Let's turn the time over to Mr. Cahoon.
Thank you, Madam Chair. I think we should let the record reflect that Peter Donaldson from my office is at the table with me, co-counsel for ARB Energy. I think we would just like to reiterate that the board's ability to impose a penalty here is discretionary. The key word is may, it's not shall under the statute. And we believe the board should use its discretion not to impose a penalty here because it is not warranted. Because of Mr. Frost's testimony that there is an underlying contractual dispute between the parties regarding the JOA and the resulting lack of division order, which is an enumerated reason for reasonable justification under the statute. And the third reason being just the unreasonableness of Dr. Percetti and attempting to resolve this matter. And for those simple reasons, we request that the board not impose a penalty. And, you know, in terms of next steps, you heard Mr. Frost say that the material is ready to be delivered, and we believe him, and that can be delivered in short order. And I think that will be the theme that we have going forward in this case is we are going to be transparent, and we're willing to answer questions and address any issues that there may be. And I just want that to be clear, that this is not someone trying to hide something from another. We are open book, and there was a disagreement on what the subpoena requested, and I came in on the day the subpoena was due, and we read the subpoena, and based on our interpretation of it, it did not include expense information. We have that information. We're willing to open up the chest and have everybody inspect and review and hopefully come to a resolution to this matter. And if you don't have any other questions, I think I'll close.
Division, do you have any comments?
Yeah, just briefly. As indicated before, the division goes by the statute. The statute requires payment within a certain time. If there is no payment, that money should be put in escrow if there's a dispute as to why it's not being paid. During the division's time being involved in this, we are still yet to hear a reasonable justification as to why payment has not been put in an escrow, as to what the payment was. We're appreciative of ARB coming to the table now and being willing to work with the other parties, but this was not the case. So, we have these rules where we can impose penalties. Well, the penalties aren't there for, if you decide you want to play now, well, we just won't do them. The penalties are there because if you didn't follow the rule, you should be penalized. And, we can argue about the dates, 2021, 2020, but here we are in 2024 and there's still zero payments. So the division's interpretation is there's no understanding of why the penalty should not be imposed, and because we do not see a reasonable justification there. Thank you.
Thank you. Board, do you have any questions? Mr. Moon.
So I don't remember the exact numbers, but it seems like the first year, in 2020, you actually had a net loss. I'm talking to you as if you're you're the attorney. But there were loss years and profitable years and loss years. And so, but there was never a billing for that net loss to Mr. Percetti, correct?
My qualified response is I don't believe so. There was, I understand there were losses in some years and gains in others.
Yeah, okay.
again qualified.
I think the board's going to need to discuss this. Do you have any further comments before we retire to the boardroom?
The last thing I would say is there's a requirement under the statute, and it's 40-6-9 7. I don't know, C. I can't remember exactly. I'll get you the. But that statute requires that if you determine there's no reasonable justification for delay, given the fact that essentially you're keeping money without any reason to do it, it requires you. It says you shall set a payment of the full amount within 90 days. And we asked the board to do that. That's November 26th. That's almost a full year after filing the request. And the truth is, if they really have the production information ready to give us today, there's no reason that we can't analyze it and compare or have a supplemental board hearing about damages before that payment's due on November 26th to come up with the final number. So I'd just like to make the board aware of that provision of the code when they're deliberating.
Madam Chair, I have one more comment
Okay.
on that. Is there were mutual obligations here from both parties, and there should not be a windfall in favor of the petitioner because he failed to satisfy some of his obligations under the agreement. And that'll be my final comment.
Thank you. Final from the division? Final?
If you really want one. My response to everything that's being said is, again, we never heard any direct testimony as to why payments haven't even not been made. We heard secondhand testimony. We never heard anything direct. The only direct testimony we have is Mr. Perchetti, who's sitting right here, and that's all we have with us at this point in time, and that's all that the division could go by. Thank you.
We are going to retire for a few minutes and talk about it, and we will be back. I don't want to give you time soon, I hope, with a decision. Thank you. We're off the record.
one. And we're back.
We are back on the record. The board has come to a conclusion, and I'm looking for a motion from the board.
Before we do that, Madam Chair, if I
Oh.
might interject with one housekeeping item,
Right,
probably appropriate to move for admission of exhibits. We talked with council and board council prior to coming back on. Now would be appropriate time, speaking on behalf of ARB's council as well, to move for admission of what was submitted as petitioners exhibits 1 through 7, most of which are illustrative. And in addition, the offer letter, if you can give me a date on that, Tyler, or say that into the record.
Sorry, I believe it was June 10th, 2020.
That sounds close enough for me to say that we're in agreement on
June
which offer letter.
2020, yeah.
Those 7 exhibits from petitioner and the offer letter in 2020 submitted by ARB.
So admitted.
Thank you.
Now, calling for a
8 for
motion.
us. No, exhibit 8 was not admitted.
Right.
Thank you for the clarification, Julian.
We are ready for a motion.
Yes,
Madam Chair, sorry, I forgot one other important piece of housekeeping. There was no request for public comment, and there was a public comment letter filed. I know the board doesn't want to open a can, and I'm not trying to, but just to make sure that we've crossed any boxes the board would like to cross.
We did receive that letter.
Thank you.
Okay. I think we're ready for a motion. Mr. Borden?
Okay, I'm just going to say this off the cuff. I move that, pursuant to Utah Code 40-6-9, the board finds that Dr. Perchetti is owed proceeds and that the ARB's delay of payment of proceeds to Dr. Perchetti is without reasonable justification. The board further finds that the funds were not held in an interest-bearing account and orders, 1, a complete accounting be provided to the division by September 6, 2024, including gross proceeds and expenses sufficient to allow the division to calculate net proceeds. 2, that the approximately $495,000 that ARB acknowledges to be owed to be deposited and held in an interest-bearing account pursuant to Utah Code 40-6-9. 3, that the money deposited into the interest-bearing account, together with any amount later determined to be owed, is subject to an interest rate of 1.5% per month as a substitute for an escrow account interest rate, accruing from the date of monthly payments of billing should have been made. This should be calculated on a monthly basis beginning January 2020. Pursuant to Utah Code 40-6-9, 7C1, the board sets a deadline of November 26, 2024 for distribution of the funds owed. If not paid by that time, Utah Code 40-6-9, 7C2 requires that the interest of 1.5% each month continue until paid. The board imposes a penalty of 5% consistent with Utah Code 40-6-9. If unresolved by the parties, including the division, by October 1st, the parties will appear at the October board hearing for final review of the amounts so the total amount due can be paid by November 26, 2024.
Do I have a second? It's been moved and seconded. All those in favor?
Aye.
Any opposed? Hearing none, passes unanimously.
Thank you, Madam Chair, members of the board.
Thank you.
Thank you. And with that, that was the final matter.
Madam Chair, just one last housekeeping at the risk of getting shot.
All right.
Would you like someone to prepare an order from this hearing?
We will have the board council prepare the order.
Perfect. Thank you very much.
Thank you. Do you have any final comment before we adjourn?
No, thank you.
Okay. Do I have a motion? We are so adjourned. Thank you. Thank you. We'll see you all in Vernal in September.